Yes, may I have kindly to mention 3 appeals for filing without the certified copy. Where it's order passed on.
Original.
Apple side.
এই অরিজিনাল মেনশনিং এর সময় থাকবে না কেন? আজ বৃহস্পতিবার না? তুমি বলে দাওনি? মিঠুনকে ডেকে বলবে urgency.
The urgency is the honorable single bench in the writ petition had directed the bank to defreeze my bank account, for which we had initiated the contempt because the bank accounts were not defreezed. But suddenly, at someone else's application who was not a party to the writ petition, but that order has been stayed in a disposed of writ petition. No, I am for the writ petitioner. I got an order in my favor that my bank accounts, which was lying frozen, should be unfreezed. That order was not complied with by the bank. So we filed a contempt application. But in a disposed of writ petition, a third party sought to intervene, and on his application, that order was stayed. In a disposed of
order was stayed.
Yes. In a disposed of writ by the same court.
Without hearing you.
Yes. The only order is that has to be heard. So now that order will stay. And not a party to the writ petition. The applicant was not a party to the writ petition.
You must have filed application.
He filed an application in a disposed of writ to intervene.
That was allowed.
That was.
When?
19th of June, the order. We have applied for a certified copy on the 1st. All 3 identical.
Yes. We have a lordship kind to mention on application.
Great.
The appeal was filed on 19th of June. Thereby indicating the returnable date on 26th of June.
No. What is the problem? When we were taking up this Harvey's determination, we found that on the returnable date, the mandamus used to send the file. Now, all these appeal applications, we have tried to say that you list it on the returnable date. But what happens in this case is that the file, after being checked, if it is defective, it will not appear. And if it is checked, it is sent down to FMA. Now they insert the FMA number and send the file. This is the problem. We have asked for an appropriate explanation.
That's why I'm mentioning this.
When was it returned?
26th of June. I served notice according.
Yes, Mr. Niyogi. What problem?
Review application, my lord.
Review of our order?
Yes, my lord.
Sitting with my lord?
No, my lord.
Then?
That has been assigned.
No. Order was passed by my brother, was not a party to that bench. So when that bench sits, you mention
that bench is not. Your lordship
Get lordship. May I be allowed to mention lordship? Lordship for inclusion, lordship.
Fresh matter.
Fresh matter, lordship.
It was not heard earlier.
No.
Did not appear in the list.
No.
Hand over. Yes, call the list.
My lord, mentioning for inclusion of matter, my lord, fresh matter.
Of what?
It's a appeal matter from the writ court.
Final hearing appeal?
No, my lord, it's a fresh matter. Mentioning for early inclusion in the list.
Means you have filed it fresh?
Yes, my lord.
Yes. All fresh applications, please hand over this link. No other mentioning? Chalo.
I demand, my lord, my client does not want to proceed with the matter, my lord. This is their letter.
State respondent.
কোথায় ছিল? তোমরা দেখতেই পাচ্ছ না তো? You are for the respondents?
I'm the respondent number 1.
State respondent.
Parties are represented. My lord, I am for the appellants.
But I'm
In the
paying,
previous order, my lord,
Yes.
but I'm paying extension of time, my lord, to file the opposition, my lord.
You're welcome.
But this is a post office matter.
2 months have already lapsed.
4 different post offices are involved, my lord, for fraud passbook and savings.
Savings account, they have said, my lord, that money has been deposited with the post office. Now they demand to return of the money after maturity. Now it has transpires that, my lord, one agent, my lord, has done the fraud. Investigation is going on. Charge sheet has been filed. The matter is pending before the jurisdictional court. So this is the position, and trial court hold, my lord, since the matter has been taken up by consideration by the concerned court below. So at this stage,
So what happens to the money? It's my money.
yes, my lord, that is lying with the post office. Now the
There is no money. Money was not deposited.
So what is the wrong? If it is his money, why should he not get it?
Fraud committed by the agent. That nothing to do with the postal authority. That is the case.
But the amount is with you now.
No, my lord.
Yes, some amount is with them. Admittedly, I have, in the writ petition, the documents which we have filed, they did not affirm any affidavit there, use any affidavits there. From there also, the post office is admitting out of 16 lakhs, some amount is lying. That amount they did not specify.
So Mr. Bhattacharya, you
And
take
last time they took the leave to file an affidavit, to use an affidavit. Lordship kindly sees that direction.
if it is his money, why you are not giving it back?
The
He will sufficiently indemnify you.
Learned single judge has held dismissed the writ petition. Against that, they have come before your lordship. Your lordship gave us leave to file opposition, my lord.
We understand, but we are asking you.
My learned friend is saying that it has not been admitted totally, my lord. It is the case of the authority that.
Already 1 month interest gone. 13th May was the order.
If you will get everything with interest, no issue, man. This cannot be.
He has to survive, sir.
Man, that is all.
আমার টাকা আমি পাবো না।
That is there. Man, if it is there, but there are so many agents doing fraudulent act with the
all right, we extend the time for 1 week, and we are fixing the matter. You come prepared on this matter.
Yes.
If that money belongs to them, and if any part of the amount is with you, we will hear the appeal. Or we may dispose of the appeal. We may not interfere with the matter. So let us cut short the
as your lord. But I
You
follow
come with a
what is
written-
passing on lordship's mind. If it admitted money, if we have admitted, we will pay it. So far, the disputed amount, that will. I follow your what is passing on lordship's mind.
There can be no dispute because he is not a party to the fraud.
As your lordship. But as I have seen, my lord, nothing is admitted. My landlord is saying, well, I shall show to your lordship.
I'll show from the documents in the writ petition itself.
Mr. Bhattacharya, learned advocate appearing for union.
Three, I am for the respondent writ petitioner.
Appellant ke?
I'm for the appellant, my lord.
There is some defect in the appeal. Day before yesterday, your lordship was pleased to give direction that
My
a
lord,
copy of
defect
the
has already been
application-
cured. Defect has already been cured, my lord. Kindly see the first order of the memo of appeal. Kindly see the first page, back side of the first page. My lord, defects, all the defects had already been cured.
There is a delay in filing the appeal.
You have filed a section 5.
Yes, my lord.
No copy has been
Filed.
given to me.
My lord, we have served. This is the affidavit of service.
Evidence, sir.
দেখে নেবো। দেখি কে receive করেছে দেখি।
My lord, what?
Section 5.
অ্যাপ্লিকেশনটা কি এসছে? সেকশন 5 টা এসছে?
There are two applications. One section 5 application and another is addition of party application.
Addition of
Yes, my lord. Since
you have made that.
yes, my lord, because I am the private respondent in the writ petition who has preferred this appeal, and before filing this appeal, my lord, one of the private respondent, namely Makhon Sarkar, did not give us a power to file the appeal. That's why we could not implicate him as an appellant. So therefore, we file an addition of party to implicate him as a pro forma respondent.
What is the dispute?
My lord, the dispute is
Please show us the ordered impute.
yes, my lord. There are two orders in orders.
Two
My lord,
orders you are challenging. Two orders you are
Two
challenging.
orders, my lord. First order dated 7th February 2024, passed by Honorable Justice Rai Chattopadhyay of this Honorable High Court.
Just a moment. Who is for the writ petitioner?
I am for the writ petitioner.
You are for.
Yes.
You have challenged 12th of July order.
Two orders, my lord. First, 7th February 2024. That order was recalled on 12th July 2024.
7th of
7th of February 2024.
that order.
In the
7th of February in the memo of appeal it is.
annex, my lord.
12th এর পরেই আছে।
আচ্ছা 7th.
হ্যাঁ। 171 stay application.
Dispose of good. সাথে petition disposed of matter
decide করে
তারপরে ওরা একটা recalling application, modification of that. উফ, recallingটা কে ফোন করলো? Recalling application you filed?
No, my lord. Recalling application filed by the writ petitioners.
Yes, you are,
Yes.
oh, you are private respondent.
Yes.
Writ petitioner means Krishnakant.
Yes.
So after that order of 7th of February,
Yes.
they filed a
Recalling application along with an addition of party.
ট্রিটমেন্টটা কোথায় হলো? নট ইউজিং, কে বলছে নট ইউজিং, not implementing the same would not be fatal. Yes, the treatment আমরা করতে হবে তার।
এটার পরে নিজের consideration which you preferred against the order of 7th February. On one hand, where is that appeal? That appeal any
Milord,
order passed?
No, my lord, that appeal has been withdrawn. My lord, kindly see the page number 169 of the stay application.
Appeal has been withdrawn
Yes, my
by
lord.
you.
Yes, my lord.
That
There are some defects. There are some defects.
So why did you prefer appeal?
My lord, I preferred appeal by challenging
7th February.
7th February order.
But what-
After that,
Why did you, how you were aggrieved by the first order? Your contention is
yes,
that their contention was the competent authority was the executive engineer.
yes,
Later they came and say that we have made a mistake, it will be Mr. Y.
yes,
So court has said, all right, let Y consider it now.
yes,
This was the first. Now you preferred an appeal against the direction for consideration by X.
yes,
So that you have withdrawn.
yes, my lord.
So now what is your difficulty if the matter is considered by the project officer?
No, my lord. I'm coming, lordship. After 7th February order, my lord, we preferred an appeal because the then concerned authority, the executive engineer,
Right.
Previously it was already settled that the egress and ingress of the writ petitioners are not obstructed at all.
So you place that before
Yes.
the project officer.
Yes,
They
yes, my
have
lord.
not attended the hearing.
The 2018 order
Yes, my lord.
is only restricted to the ingress and egress.
Yes,
Now they come up with the new plea that you have encroached into their land as well as PWD land.
yes,
So
The 2018 order really doesn't operate as a res judicata, if that's your
So
point.
that is my case, my lord. The main writ petition was preferred that in and by imposing an
That writ petition.
that writ petition
Earlier writ petition.
at
What was the order passed in the same?
2012 writ petition. The
18
order is there, my lord.
The 2018 order. Have you annexed?
Yes, my lord. Kindly come to the page number 113 of the stay application. The the honorable coordinate bench of this honorable court suggested that the free egress and ingress from the public road of the premises repetitioner is not obstructed.
Page 113.
113, my lord.
Who was the respondent number 4?
The respondent.
Oh, executive. Have you annexed the writ petition? This writ petition have you annexed?
No, my lord. I have not that writ
No,
petition.
not that.
I don't have.
Your writ petition in which 7th February order was.
Yes. That writ petition is annexed.
What is show us the prayer of that?
Yes.
That is page 35.
Page
34.
Yes, my lord. That is the writ petition.
One 7782. Order is to 11749.
आगे read petition. It is 1778. Second thing, এটার প্রেয়ারটা দেখতে চাচ্ছি। পেজ 34 এ বলছে আগেরটার অর্ডারটার উপরে বলছে এক্সিকিউটিভ ইঞ্জিনিয়ার এভিডেভিট করে বলে দিল যে দেয়ার ইজ নো ইগ্রেস এন্ড ইগ্রেস। এবার তুমি যে পয়েন্টটা আসছো তোমাকে নিয়ে তো আর আমি পারবো না, তুমি এখন অন্য পয়েন্ট পেয়েছো।
My lord, if I may assist your lordship at this juncture, well, the last order, modified order was instead of executive engineer, project director 2 will pass the order. That was the order, modified order of
But
the
he
learned
was
judge.
not a party to the proceeding. Project officer was not a party.
Project director, yes. But
We have
then
filed an
project
application for
director has
addition
already
of party.
passed an
That was
order.
also allowed.
Project director has already
Yes,
passed
yes,
an
yes.
order, my lord, I have got it on 9th of June.
2 application we have filed for recalling of the order
9th
and
of
another
Yes.
for addition of party.
This is a subsequent event, well, it is not brought on record.
9th of June 20.
25. Directing, well, the project officer 2 has already passed the order, directing removal of encroachment under section 10 of the
Oh.
Act. That's what I was,
Kindly come to page
that's what I
1.
was saying, well, if I can
Sir,
place-
President, kindly come to page 171
The
where
project officer has passed an order.
Yes.
That has been communicated to him.
Yes. What
I think, well,
what
it
has
is-
happened
yes,
on
yes.
regular occasion, the hearing
But
took
when
place.
was that project officer order passed?
9th of June, may I hand up, or I have a,
We don't have, Mr. What can
Page
you have to
171.
to cast a lordship. I have
Page,
to- what is lordship
page
was hearing?
171.
Oh, we make Xerox and take it, or you give us free of charge?
It's for your lordship, it's
Oh.
for the court's record.
Very good.
Kindly have a
So
look. well,
thereafter, you can come with an addition of party. Just did not TRB.
well, the order under appeal has already been acted upon.
So this officer granted him an opportunity of hearing.
Kindly peruse the order. May I read? May I read?
Order তোমার কাছে নেই ওটা।
Page 171. Kindly see.
That is this order.
No, it's not this. It's not that.
Page 171 of the order here,
The order.
6 March 2025, where it is noted that, however, on the basis of the prayer of the private respondent number 6, 7, and 8, that is Buddha Ghosh, Ganesh Ghosh, and Prabhas Ghosh, the appellant before your lordships, their advocate Pompa Mojumdar, filed letter dated 27 January 2025, that is the 5th paragraph, have requested for deferring the date of hearing of the schedule dated 28 January 2025 on medical ground, and the next date is hearing was fixed on 20th February 2025. Then on hearing held on 20th February 2025, no private respondent were present, and considering the repeated absence of the private respondent, final opportunity was granted to the private respondent, that is the number of the respondent, to attend hearing to the scheduled date on 6 March 2025. Today, no private respondent number 6, 7, 8, 9, 10, 11 have appeared for hearing on 6 March 2021. That is their conduct.
Now, Your Lordship may peruse the order that I have just handed up.
Yeah, just. PLRও inspection করেছে। This is under the Highways Act, no?
Yes, section 10 of the Highways Act.
Section, there is an appeal.
There is an appeal.
Statutory appeal
Yes,
is
yes,
there.
yes.
So, Mr. This has been communicated to them, this order?
Well, this is the letter. Lordship, kindly have a look. Well, the first 9 June order is the removal order. And then, Your Lordship, will find well, the 26th May 2025 letter addressed to all the private respondents the learned friend is representing.
That is to appear for the hearing.
Yes. Well, notice given, notice was given on 26th of May, and the order was passed on 9th of June.
Then to remove the encroachment. Orderটা আছে 6th of March, যেটা 171 এর রয়েছে।
Or the notice, it starts with notice was served
170
under section 10(1).
তো পাস হয়েছে 6th of March, ঠিক আছে?
6th of March হলো।
আপন 9 জুনে কি হলো?
9 জুনে বললো remove করে। To remove encroachment from boundary.
আর তাহলে মেয়েতে কি অর্ডার হলো?
Communication each and every date project officer আমাদেরও চিঠি পাঠাতে হতো।
এখানে নিশ্চয়ই উল্লেখ
পোস্টাল অ্যাড্রেস।
এখানে
তো সেই কপিটা আমার কাছে নিয়ে অ্যাপিলেন্টের কাছে দিবি।
আন্ডার লেটার আন্ডার 21শে মে 2000
মেল দিয়েছে, সেই মেল প্রাইভেট রেসপন্ডেন্ট।
সিক্স মার্চের অর্ডারটা হচ্ছে রিমুভ করতে বলুন। 6 মার্চ
এনক্রোচ করেছে।
হ্যাঁ, না সেই জন্য তুমি এরপরে কি হলো?
Directed to do in 28 days.
হ্যাঁ, ওটা
28 দিনের
28 দিন, তারপরে কি হলো? 9 জুনের অর্ডার,
তারপরে 26শে মে।
26শে মে সেটা কোথায়?
9 জুনের ঠিক পরে এই মার্চটা
26শে মে। 26শে মে বললো
করো।
Seven days notice. This is a 21.
একটা মেল আছে 28/5 না কবে একটা।
Mr. Where is this bold letter memo? 21st May.
Bold letter, this. This is 21st. Memo number 1106 land
Private response.
eviction KLY 21st May 2025. 21st May
Meantime,
I don't have any copy there.
এটা হচ্ছে অ্যাডভোকেটের চিঠি থাকে।
না না আমাদের একটাই কপি
Your request self-explanatory and without any document. Copy enclosed. Where is your
2025 letter
advocate's
is not
letter?
with me. It is not with
Where is your advocate's letter of 28th May?
My lord,
21st May.
28th May.
28th May. That was sent by email. I have got only one copy.
21st May.
আমি বুঝলাম ওটাই 21 মে, এটা 28 মে দেখছি। Then what is this memo of eviction of 21st May, Mr.
Or
My
21st
lord,
May, my
we
lord,
have
letter
not
is not with me,
got
my
the
lord.
order of 9 June also.
No, you have replied on 28th of May, sir.
28th of May.
Where is that email? সেই মেলটা আছে আপনার কাছে? এই যে 28 May এটা চাইছে।
My lord, this I have got only one copy, my lord. I can.
28th May.
Yes.
28th May.
This is the mail, my lord, the advocate's letter.
Yes, my lord. 28th May. Yes, my lord, I have got them.
Now, Joseph, দাও।
তাহলে সুবিধা হবে তো করে।
হ্যাঁ।
একটা কপি দুটো কপি দিয়ে
দুটো copy।
তাহলে একটা কপি আছে একটা কপি আছে।
একটা আমাকে দাও, আমার আমারটা দিয়ে দিয়েছি। The 26th May.
Yes, sir. How can we interfere in the appeal?
My lord,
6th of March 2025 order which was passed in your absence because you did not appear. That was an order under section 10(1). Now on thereafter on 6th March it was complied.
Orders of 6th of March.
Hmm. 6th of March, you have got the copy of the order. And 9th June. Mr. This is in connective of letter under reference 5. Was served upon the according to this to remove her. Where is this memo of 21st of May?
My lord, it is not with me, my lord. I'm so sorry, my lord. I can't.
21st of May. I have an order of 26th May, my lord.
26th May.
26th May, 2024. 5.
Order?
Yes, my lord. Notice 20, not 21st, it's 26th May. Notice for removal of unauthorized occupation.
That's a notice for removal, not an order.
Notice for removal. my lord.
So there is the entire thing has become infructuous because the order which you are challenging,
yes,
that order has already been implemented. Section 10 order has been passed. You have been asked to remove the structure.
My lord.
Kindly excuse me.
You are engaged.
My lord, actually, my lord, he filed the appeal. I asked the client to have a conference with him to understand the entire matter because I was not in the read code. Client
So
instructed.
you are not engaged in the matter.
I am engaged by the client, but as I wanted to have
Client has given wakalatnama in his favor.
in his favor, but
So you are not in the picture, sir. Client, there is no instruction that you would be leading him. You are just coming inside the. You're just coming. No, sir. This we cannot allow.
My lord, possibly I'm not clear. Yesterday, my lord, the client came to me, informed me that I should have a conference with him, but I requested that since I have not a
Did your
conference with
client give
him.
any instruction?
At the
that
time,
you engage?
I don't have that
clients are here itself, but
He is saying that he has no,
have a conference.
he is saying that he has no information.
Yes,
And
yes.
day before yesterday, another
I had
another
one
counsel
information.
appeared and said that
I had one
he is just.
I had one information, my lord, from my client that one learned advocate will assist me. But who is that? I don't.
Oh, acha.
Yes, my lord.
Actually, my lord,
In
I
this
want-
matter, Mr. Devashish Chattopadhyay is also is appearing and leading me. Just because of he is in a medical checkup today, he could not come. So, my lord, my humble request to keep the matter on next week to end the hearing, my lord.
Last occasion, another counsel appeared saying that I am just briefed in the matter.
That is, he is Devashish Chattopadhyay, my lord. Is a
we
pres.
have
Yes,
asked
my
the
lord.
client, all of them
Sway.
present here.
Yes.
So,
Not play with the court.
ঠিক আছে, নিয়ে যেতে পারি।
না না আমি তোমার সঙ্গে বসবো বলে I
আচ্ছা,
asked them যে not
This is not proper.
Next week এ রাখি।
হ্যাঁ
Okay, go on.
Next week এ
After full-fledged hearing.
An order is an appealable order under the Act.
Yes, the cause of action does not survive.
Survive.
Everything has come to an end.
The order has already been complied with by the authority. After giving opportunity of hearing, they have not availed.
It is aggrieved by the order of 6th of March.
Severity appeal is there.
কোথায় হাইওয়ে একটা কোথায়?
Yes, yes.
আমি একটা করতে চাইছিলাম
Sorry.
তোমাকে জানাবো
Yes, what new, so you know the facts of the case?
My lord, I am aware, my lord. The difficulty only what I came across yesterday that my learned friend was appearing in the court below. He filed the appeal. I asked my client that I should have a conference with him and thereafter appear. But since the matter is fixed to today itself, my lord, may I pray your lordship, my lord, to give 2 or 3 days so that we can have a conference and come back. Though I am aware, but I want to have a conference with him. And may I place what has happened? Because I know
So you take time for conference or you do
my
the
lord,
matter.
the appeal was withdrawn as the order has already been recalled. The impugned
Sir,
order
you
was
go through the
recalled.
records and this half-hearted installment.
I'm
argument
extremely
will-
sorry, my lord, for the difficulties.
After we had it for 15 minutes, you come inside and say, I am appearing.
My lord,
This is not the procedure
I am
adopted.
extremely sorry, but yesterday
So
only, my lord, they came.
Maybe that
but-
is not an explanation.
No,
Na?
no,
If your
I
client has
understand the
given you-
difficulties, but
he is a junior member, what he will say?
no,
He will say, I do not accept you as my senior.
no, my lord, it's not his fault, my lord. The client should have informed him yesterday. It is the difficult. Therefore, I personally, my lord, informed him today that client came and have a conference thereafter. Just to the matter, my lord.
There is
It
a
is
provision
not
for
his
appeal.
fault in any manner. It is only a communication gap, but only it happened yesterday, and the matter I
Have
found
you
is
given
fixed
copies
today.
of the application to them?
No, my lord, they have not given, my lord.
You have not given.
Even a copy of application they have given, but I was made to
Who has
understand.
given? Don't say they.
I'm the respondent.
Have given. There was a section 5 file, therefore I
Have you
thought that
given them the copy of the section?
one day to have a conference with
There is
him
a
so
provision
that-
under section
Kindly fix the matter
10
next week.
subsection 4.
Therefore, I asked all of
Provision
the
for
clients
appeal
to
is
be
there
here.
within 15 days.
Subsection 4.
Subsection 4 of section 10.
When
Any
he is
day,
asking for an opportunity for submission through
Yes,
senior,
but this will be the third opportunity.
opportunity.
This will be today's
কিন্তু সে-
third opportunity.
third নয়, আগের দিন copy
there
was
were certain
directed to be
defects, sir.
served only. On last date, your lordship directed serve copy and it will appear. I understand the difficulty, but because of this situation, I asked my clients to be here. So that may not. Kindly forgive me for the embarrassing situation, but
on the prayer of the learned advocate appearing for
have informed him, but as it started, my lord, I was unable to inform him. I am sorry, my lord. Kindly.
সেটা পড়ে দিচ্ছি আগে এটা
4 and 5, Mr.
4 and 5. For going to the improving order, just 5 minutes time, the short facts of the case. There are at least 4 writ petitions and 4 public interest litigation, and another before the National Green Bench. The allegation is that I have
Another before the Green
National
Bench.
Green
Green
Tribunal.
Tribunal.
National
Green
Green.
Tribunal.
The allegation is that, my lord, I have constructed a house in 2 katha and 2 chotaks area. Out of that, 0.9 shotaks land fallen in the Pukur Park, bank of the number of cases has been filed. In one writ petition, a direction has been given to the block land and land reforms officer to submit a report. And also the officer in charge, Behala Police Station. You will also kindly turn to page 28 of the stay application.
Which appeal you are placing, Mr. Sharda?
The first one, item number 4.
761.
761.
Page?
Page, my lord, 28. This is a report submitted by the block land and land reforms officer, Kolkata. It starts from page 28. If you will skip the next page, kindly turn to page 29.
Pursuant to court's order, it was.
In terms of the court, sir. That will appear from the first paragraph at page 2. Inner page to pagination is not correct, my lord. Inner page 2 of the document, page 28. Now, your lordship, kindly turn to page 29. Inner page 3 of the document. Serial number 3, paragraph 3, Roman 3.
Yes.
Paragraph Roman 3, page 29. As per field inquiry conducted on 13th of June 2022, no visible evidence of alleged filling of the water body was found. This is the observation. However, stacking of some household rubbishes was found in the southern corner of the water body. Presence of water has been found in the arrest plot number so and so during the spotted work. So it was found that there was no filling of water body. Now you also kindly turn to page 44, another report. This is submitted by the officer in charge, Behala Police Station, which will appear from page 45. It starts from page 44. Kindly turn the page 45. I am the officer in charge, second paragraph. Then kindly turn my paragraph number 3 at page 45. The first paragraph says, I am the officer in charge. Then paragraph 3, Roman, that I beg to place the following facts in connection with the instant proceedings for the kind consideration of the Honorable Court. This is also in terms of the court's order. During inquiry, your lordship at page. During inquiry, the premises number 139 Diamond Harbour Road, Kolkata 34 was visited, and it was found that a pond is situated there. On bare eye, no such filling was found. Their local residents were also contacted, but they were unable to throw any light regarding the filling of the said pond. During the physical inquiry, it was found that the total residents dumped some garbage at the same report. So it was not found there is any pond has been filled in. Now, your lordship, kindly come to another report has been submitted.
Your building is in which
plot? You also kindly turn to page 60, page 60. Page 60.
This pond is plot number 13844.
You would like to kindly come to page 60. RS record of right.
No, that is now what thereafter
now,
what?
Now you will also kindly come to page 64.
64.
Well, there is no dispute so far the land is concerned. Page 64. This is another report submitted by the High Power Committee in terms of the court's direction. I have submitted before your lordship number of proceedings. In another proceedings, this direction has been given by the division bench in appeal, direct forming a high power committee, and they submitted a report which will appear from page 64. Your lordship need not go through the page 64. Kindly turn to page 65. There is a box in the top of the page 65. Kindly come to serial number 2, tag number 13845. This is my tag. Total area 009 Pukur Park. Kindly take note of the area. I have submitted only 0.009 Pukur Park. Then kindly turn to my lord, last paragraph of the document. At page 65. It was decided that the District Land and Land Reforms Officer South 24 Parganas will be requested to submit a status report mentioning wherein any encroachment of the land filling has taken place in the RS plot number 13844 of Mauja Swanso early as possible after conducting field visit. Accordingly, letter number Swanso were issued. The next paragraph, my lord, next page. Acting to Swanso and having no reply, Swanso, the District Land and Land Reforms Officer did not file any report as per the High Power Committee direction. Now, your lordship, I have been directed by the local police authorities not to raise the construction. I have been compelled to come before this court. An order has been passed at page 73. Justice Sanjeev Banerjee, as his lordship then was. So, lordship, kindly turn the page 73. The mandatory direction to allow me to raise construction. This order has been passed at page 73 on 29th of August 2013. I have a sanction plan. Kindly turn to my lord. Details of my plot has been given, paragraph 2, then third paragraph at page 73. Since the sanction plan is available and it appears that the police authorities may have proceeded to stop the construction.
Kindly come to paragraph 1 first.
State and the corporation are disputed and it is not disputed that there is a plan sanction. There is no dispute.
Of premises number 139 by
Yes,
1.
this is my premises. This is my premises.
This pertains to plot number 13844.
There is no dispute about the same. There is no dispute. This is not the dispute at all. Since the sanction plan is available and it appears that the police authority may have proceeded to stop the construction at premises number 139-1 Diamond Harbour Road, due to bona fide mistake, WP number Swanso is disposed of by permitting the petitioner to resume and complete construction strictly in accordance with law and the plan sanctioned by the corporation unless there is any other legal embargo in the way of construction being completed. The construction at premises number 139 by 1 Diamond Harbour Road cannot be impeded on the strength of any order passed in Swanso. Diamond Harbour Road is not the subject matter of that petition. So this is the direction. In terms of this direction, I've completed the entire construction. This order has been passed, my lord, on 29th August 2013.
No, cannot be impeded on the strength of any order. What is this writ petition?
I am coming to that. Before that, this order has been quashed. The order passed by Justice Sanjeev Banerjee, as his lordship then was, an appeal has been taken out by the private respondents and this order has been quashed. But kindly take note of the date. This order has been passed on 29th August 2013. Now, your lordship, kindly turn
Private
to...
respondents are before us?
Yes, yes, all. I have served all.
I am for the state respondents. We are for the state respondents.
You are for the private respondents?
Lord, we will landed party in this matter. We get an application for being added as a party because they are the execution of the by the public interest. And Lord, we filed the deed by the deed.
No, you filed an addition of party application.
Yes.
That is appearing.
That has been allowed by the report and thereafter after consideration.
So you are Sumitra, Subir and Manoj.
Yes.
You are appearing for them. Very good. So this order has been quashed.
Page 107.
Because there are 139 by 1 or 121 same premises. They misled the code that one is postal and postal address and another is the.
We shall hear you, Mr. Ghosh. Let him.
That's why it was.
Yes, Mr.
I have shown to your lordship the single judge passed order on 29th of August 2013. Then kindly turn to page 107. But this is the division bench order. Kindly see the date 7th April 2014. I have concluded my entire construction. Kindly turn.
This is a appeal preferred against which order? Justice Banerjee's order?
Mine. Kindly turn to page 109. What is the order?
This is by the private respondent.
My lord. Page 109.
Anuj Hod is not here, Mr. Sharan.
One of the private respondents.
Oh, achha.
I have served all.
Anuj is not a party here.
Anuj is a party. Anuj is a party added.
No.
I am showing you.
Pursuant to leave, Sumitra, Subir and Manoj added.
Yes, madam. The application he is respondent number 4.
Respondent number 4. Respondent number 4. Sir,
This appeal was preferred by Onu.
Respondent number 4 in the appeal.
Challenging Justice Banerjee's order.
My lord.
Now, in Justice Banerjee's order, Onuj was a party.
Yes.
Then why Onuj you have not implemented?
Yes, respondent number 4. Respondent number 4.
ভুলে গেছে
Onuj Har Chaudhary.
ভুলে গেছে
Don't say sorry.
Yes.
Kindly come to page 107. This is the division bench order. Need not go through the same. Kindly turn to page 109. The operative portion. Last part, one paragraph. In the circumstances.
Yes, you are showing us, Mr.
Page 109, the operative portion.
Yes.
Last part, one paragraph. In the circumstances. Have you got my last part, one paragraph.
Yes.
We set aside the improving order passed by Justice Banerjee, permitting the respondent number so and so to the file the between opposition before the single bench. Thereafter, the single bench to decide the matter, taking into consideration report of the High Power Committee and various orders, documents, possessions. So now the single judge has disposed of all the repetition, both the repetition. Before that,
at the stage when the appeal court heard it on 7th April,
construction has been completed.
Completed. So show us one line in that order that construction completed.
No, that is not reflecting. But I have been that order has been quashed.
Directing construction stands.
Yes, yes.
Now what did the
now, one document I am showing to your lordship, my lord, page my lord 60. RSROR.
No, don't show us now.
My lord. Then my lord, the page 180, the order of the learned single judge. I'm cutting short the matter.
Your order of the learned single judge challenging the order passed in compliance of this order of the appeal court.
No. Division bench directed to dispose of the repetition.
Now what did the court
say? Two repetition was pending. In terms of the order, matter was heard at length, and this judgment has been delivered, which is challenged in both the appeals at page 118.
So why two repetitions?
There are two repetitions. Common judgment has been delivered.
No,
one against the threat of the police, which has been disposed of by Justice Banerjee. That has been revived.
So, the which you showed us just now.
Pilot.
That is page.
That is
page 73.
My lord. And another is the challenging the report of the High Power Committee, both filed by my client.
But report of High Power Committee was in your
some observation part, some observations.
Achha.
Now your lordship kindly turn to the impugning order at page my lord 118. This is an order of 19th of February 2025. But today I am not going through the entire judgment because there are other facts also. If you lordship straight away come to the ordering portion, which will appear from page 129, paragraph number 31. Page 129, paragraph 31 and 32.
Yes, in the light of the above.
In light of the above, I find it appropriate to dispose of both the repetitions which have been pending since 2013 by directing the district magistrate and collector as well as the deputy director of fisheries to conduct inquiries in compliance with the order of the Honorable High Power Committee. They are also instructed to resolve the issue while taking into consideration the order of the Honorable Division Bench passed in MH number so and so, and after affording an opportunity of hearing to the petitioner and the added respondent. However, while deciding the issue, the district magistrate and collector shall consider the matters raised by the petitioner in their petitions and assess whether the benefits under the clause 166 of the LR manual or any other relevant provisions of West Bengal Land Reforms Act 1955 or any other applicable enactment can be extended in favor of the petitioner. It goes without saying that before making a final decision, the district magistrate and collector shall also consult the appropriate department of the matter. It is clarified that if any decision is made by the concerned district magistrate that is prejudicial to the interest of the petitioner, a reasoned order shall be passed, and same shall be communicated to the petitioner until a decision is made. So. The status quo shall be maintained regarding the nature and character of the petitioner. But this order has been passed, I have shown to your lordship, 19th February 2025. At page, my lord, if you lordship kindly see the first page of the order, at page, my lord, 118, 19th February. Now, what happened, my lord? Behind the back of my knowledge, before the Central Green Tribunal, another application has been filed.
By whom?
By one, my lord, kindly see. Banipata Mukherjee, one of the people of the local. Banipata Banerjee, kindly see. He lodged a complaint on the same ground, and an order has been passed. Kindly take note of, my lord. 8th of January 2025. Neither the state authorities nor the private respondents ever intimated the learned single judge that this is the conclusion of the Green Bench. Kindly take note of. The separate report saying there is no filled in, even if there is any filled in by the pond that has been recovered. Kindly take note of, my lord, page 131. This is kindly see the date, 8th of January 2025, whereas learned single judge passed the order on 19th February 2025.
So what is your prayer before us?
But this inquiry which has been directed by the learned single judge cannot be done because this report is absolutely my favor. Kindly take note of this is a small order, page 131. Two reports have again been filed.
But you are protected, Mr. Shah, right?
Kindly take note of the report. The district magistrate and district collector both submitted reports saying nothing wrong is there. And which order will prevail? Order of the learned single judge or the Green Bench? Because this is earlier order that has not been brought to the notice of the court.
Mr. Sarai, how can we stop an order by which the matter has been relegated for consideration?
Kindly take note what is the report.
While consideration,
that has been considered. Report has been submitted before the Green Bench.
Green Tribunal order has been passed after disposal of...
No, before that. That was not what. I am repeating, my lord. 19th February 2025. Single bench.
NGT is 8th of January.
My lord.
So this was not brought to the notice of
the
now, Mr. Shah, we are just thinking. Should have preferred a review before the learned single judge saying.
We have. That has been dismissed on the ground. The very peculiar ground is that civil procedure code is not fully applicable to the repetition. Well, kindly take note of.
So you are before us against which order?
First order, because review order has not been interfered with the first order.
Your review has been dismissed.
Dismissed.
You should have challenged that order also.
This order upheld, order page 118. I have annexed the said order also. But order.
But the refusal of the learned single judge to review the order.
Refused to review the order.
Formal
upholding the order of his own order. Now, your lordship, kindly remember. The order which has been passed by Justice Chatterjee in the writ petitions, that order is revived. Unless I challenge the same, I cannot paying for quashing of this order. And so far review is concerned, your lordship knows, my lord Supreme Court time and again says, if the review order is not interfered with the original order, no appeal lies. Only in case of there is an interference.
Now, what order you
kindly come to my lord the Green Bench order. This report has again been submitted in my favor. The court directed to consider by the district magistrate. What is the order? Kindly see.
So this page 131 National Green Tribunal, you were not a party there?
No, nothing. I have no knowledge. That should have been brought to the notice of the court by the state. State represented submitted report. Kindly take note. Very small order. Kindly take note. Kindly take note. First paragraph. Mr. Banipata Mukherjee had sent a letter petition to this tribunal, which was treated and registered as OA number so-and-so, complaining about encroachment of her pond existing in the measuring so-and-so. The above OA was disposed of by this tribunal by order dated so-and-so. In our view, the above complaint in the first instance can be looked into by the district administration and concerned authorities. Hence, we constitute a joint committee. Kindly take note of.
Interference.
whatever has been directed by
ফাইন্ডিং এলো এটা কেন জজ ইন্টারফিয়ার করলো না আমি বুঝতে পারছি না এটা কেন অনেক বড় অর্ডার দিয়েছে
আমরা জানাই
বলছে যেহেতু স্পেশাল সেটা হচ্ছে পার্সোনাল is the central issue of this litigation concerns whether the building was constructed on embankment or violation of the law. There is no possibility of passing any order different from the one passed by court, even when considering যেহেতু
already report filed করে দিয়েছে চারটে হয়ে গেছে
বলেছে নাথিং রং
এই যে হচ্ছে inspection building department has made the following
আগের কথা বলছে আগের কথা this is KMC
হ্যাঁ তারপরে 6 এ paragraph 6 recently on 23/11/24 photographs
it is as per order of writ petition
none has appeared for the applicant correctness of the report is not challenged
এটা তো KMC রিপোর্ট না
DMA report basis the
Mr. Sir, whether pursuant to the tribunal, after they went to the tribunal, any report was filed by the DM in that order, before the tribunal? Only KMC filed.
and I think this matter requires to
no. It's the DM's report. Come to paragraph 6 of the
both. So far the tribunal is concerned.
Come to paragraph 6, Mr. Shara.
Yes, I have seen, my lord.
So
both have filed report.
No. So the DM by his report of 6th of January 2020, the additional district magistrate, and he has then incorporated. This is part of the DM's report. He has incorporated the KMC's report as part of his report.
Yes, holding that even if there is any filling up, that has been removed. Even if there is any filled in by the
was that portion.
Pilot kindly turn first pilot kindly turn to page 131. The committee has been constituted. Then paragraph 6. that in compliance and obedience to the above mentioned order, it is submitted that the Environment and Heritage Department and Building Department of the Kolkata Municipal Corporation respectively had submitted an action taken report regarding personal so and so. The next page.
Where you are reading?
Page 133, Lordship, kindly come. Paragraph number
Let us
114.
understand. Page 131 is the appeal against the Eastern Zone order. This is before the principal bench.
Kindly come to page 133. 4 subparagraph Roman 1. The site in question, that is Swansea Diamond Harbour Road, near Behala Diamond Harbour Road, Government Swansea, was inspected on 9th July 2024 by the officials of the Environment Heritage Department, Building Department, Municipal Corporation, Municipal Swansea. After receiving the complaint of illegal filing of Swansea, the next applicant of the above mentioned order body, this department inspected the site on 3rd August 2021, and it was found that a portion of the water body filled up in comparison with NRSS Swansea. As per NRSS IML, the area of the water body Swansea square meter, out of which approximate Swansea portion has been filled up. Then kindly turn to page, my lord. Paragraph 6, page 134. The last report, 3rd November 2024. Paragraph 6, page 134. That recently on 23rd November 2024, photographs and sketch map have taken submitted to the office of the district magistrate South 24 Corona, showing that the filled up portion of the pond in question has been removed. The same has been restored by the Kolkata Municipal Corporation. This is a report of 23rd of November 2024, latest report. Then what further inquiry, further inspection does arise?
So who is this Banibroto and Partho? They are the owner of the pond plot.
Yes, legal heirs of the. Kindly turn to page 136. Kindly turn to page 136, order in portion of the tribunal.
136.
Paragraph 8 and 9, the operative portion.
Yes.
None has appeared for the applicant and correctness of the reports of is not challenged. Kindly take note of. As per the reports, encroachment of portion of land of the Swansea has been removed and the pond has been restored. In view of the compliance, no further direction are required to be given Swansea miscellaneous applications with disposal. But I think, my lord, unless there is a direction for filing evidence, this matter cannot be disposed of because there are so many persons. I shall file the paper book, or if your lordship kindly.
So what interim protection?
Interim protection is already there by Justice Singh.
Yes,
Status quo. Status quo. Only status quo. I am ready, my lord. If your lordship fix the matter any day, I have no difficulties. The dispute is going on. But this is a dispute arise.
Yes, Mr. Vasu.
My lord.
How many times you will conduct inquiry?
Well, it kindly appreciates one thing. My learned senior friend has invited your lordship's attention to the order passed by the learned Green Tribunal.
also said that go before the go to the DM. You place the order of the tribunal also. Then he will consider that and he will pass a reasoned order, because we understand that how many times an inquiry will be conducted. But if you are saying that you are protected by status quo, we will admit the appeal, but the DM will pass the order.
Subject to lordship.
Huh?
The report subject to lordship consideration. His report has been submitted.
That is why we are asking you. You are.
Is there any requirement that will be overreaching the order passed by the tribunal? Tribunal dispose of the matter, holding there is no filling of bonds. Last paragraph of the order. No appeal has been preferred against that. This order stands today. If any order passed directing any authority to consider the same again, that will overreaching the order passed by the Green Tribunal, who are the highest authority so far this subject is concerned.
No, that is in respect of the pond plot.
Yes.
Their allegation was you are encroaching upon the pond. Original story was that you have encroached upon the pond, but your sanction plan pertains to a separate plot noted by the BLRO himself, and you have raised a construction. Now we can admit the appeal, but then what happens? We are not stopping the DM from passing a fresh order.
But that should be stated. Well, that should be stated. Why I am saying.
You have passed any further order, Mr. Vasu?
My lord, there is no order. My lord, what I am just trying to invite your lordship's attention, my lord, kindly sees page 133. The order passed by the learned Green Tribunal, as my lord, my learned senior friend has drawn your lordship's attention. My lord, page 133, Roman 1, the site in question, that is 321 Diamond Harbour Road. Now, my lord, this writ petition and the order impugned, as I understand, it is in respect of a premises number 139 by 1 Diamond Harbour Road. The premises number is altogether different. Now, lordship may have a kind look. The order passed by the Honorable Division Bench, page 107, my learned friend has relied upon. Page 107, yes. My lord has found it. The relevant portion is at page 108.
This premises number is...
yes, 321, the Green Tribunal, yes. Now, my lord, page 107 and 108. হ্যাঁ ঠিক আছে 107 এর লাস্ট প্যারা সেটাও ঠিক আছে
2021 ওটা হচ্ছে 139 by 1
108 my lord. My lord.
His plot is 139
by 1. That is the subject matter, subject to your lordship's approval, is the subject matter of both the writ petitions. Now, my lord, the subject matter as it appears from the... Yes. Now, my lord, this is not disputed. My lord, kindly have a look at page 108. The 107 is the order passed by the division bench of this honorable court in the public interest litigation. Only one finding and or observation made by this honorable court. I am drawing your lordship's attention. My lord, after hearing the learned counsel, we are of the opinion, my lord, 100-8, lordship may kindly skip over the first 3 paragraphs. Page 108. After hearing learned counsel, we are of the opinion that this aspect as to whether Dag number, premises number, diamond is mentioned in petitioner application with the officer in charge Behala contains the correct facts where the respondent number 6 bound to demolish. So, my lord, this is the observation made by the honorable division bench on the basis of which the honorable single bench of this honorable court passed the order which is impugned before your lordship. My lord, the subject to your lordship's approval, my lord, read court is not the fact-finding court. The district magistrate, along with the concerned officer of the fisheries department, has been directed to conduct an inquiry. Nothing prejudicial to the interest of the appellant writ petitioner is here, my lord. The district magistrate, as it falls from your lordship, my lord, the district magistrate, along with the concerned officer of the fisheries department, they will make an inquiry. There is a stay, my lord, the constructions as.
Then what is your reply to the earlier report filed?
My lord,
Report
the
which was
earlier.
filed by the police, this page 108.
My lord.
Appeal court says after hearing word of
My
the
lord.
opinion, the whether DAG 18345,
My lord.
as mentioned by that pigeon, filed with the officer contains the correct facts, and whether respondent number 6 is bound to demolish the construction or not is required to be looked into by the single bench.
My lord.
But earlier there is already a report that he has raised a construction on a different plot.
My lord, that is the subject matter, subject to your lordship's approval, the subject matter of the Green Tribunal.
No.
Yes, my
Kindly
lord.
come to the
Premises number 321. 321.
Division bench
And
directed
this is
to cause inquiry
139.1.
of both the plot. Kindly turn to my lord page 26. Entire thing will be clear. Page 26 of my stay application. The first division bench order. At page my lord, say 26. Second paragraph. The allegation in this public interest litigation is that the water body pond involved in DAG number 13844. This is my lord. 321. Plot number 321, Diamond Harbour Road. And DAG number 13845. This is my DAG 139 by Diamond Harbour Road. This has been inspected and time and again report has been submitted before the appeal bench and before the writ court. These are the two plots of land. According to them, 13844 is pond and 13845 is the bunk of the pond. And all these reports have been submitted before the Garnet single bench or before the division bench in respect of both the plots.
Now, my lord, today the subject
So,
to your.
Mr. Chhara, it has to, your problem has to end permanent.
My lord.
Now today, suppose we stay the impugned order and restrain the DM.
No, what I'm praying, let them conduct inquiry, whatever let them, not to take a final decision till this was allowed there. Nothing will be prejudiced. If it goes in my favor,
yes, but
kindly see the learned single judge order.
What did the single judge say? Kindly show us.
Kindly take note of.
Page 120, 130. Shall consider the matter raised and assess whether benefits can be given, can be extended. Just saying before taking a final decision, shall also corner. If any decision is made by the concerned DM,
my lord,
that is prejudicial to the interest, a reasoned order shall be passed and the same shall be communicated.
My lord,
until a decision is reached, the status quo shall be maintained.
Yes.
So, my lord, final decision and action taken. That part should be stated. Because your lordship kindly consider, I filed a review also. And what is the observation of the review court? This document admittedly state has not brought to the notice of the learned single judge.
Well, that is
dispute is from 2011.
21. That plot.
Kindly come to my lord, 1 second, my lord, page 26. Direction, then report.
No,
Get-
that,
no. What is the report submitted in terms
we
of
are asking what is 321. That you don't know, my lord.
321 is the pond. 321 is the pond.
321 is not.
Yes, pond. 321 is the pond.
139 by
139 by 1 is
is
the
your
bunk,
premises.
according to them.
Yes.
Pukur Park. That has been directed by the division bench to take in inspection both. And in terms of this order, by page 28 and 29, report has been submitted. I have shown the first instance before your lordship 2 reports. This is in terms of the order, page 26. In respect of both the plots, page 26 is the order passed by the division bench, decided over by Justice Srivastava, as the lordship then was. Then page 29 is the first report by the block land and response officer, paragraph number Roman 3. And next report is page 44. In respect of both, all together, page 44 is the police authority. 2 reports filed in terms of the direction of the honorable division bench.
139 is
139 by E1 is by residential house.
Yes.
According to them, this has been encroached the bunk.
And 321 is
10 is the pond.
and 139.
139 is the, according to them, bunk. That is the Pukur Park.
Where is that tabular table you showed us? That 2 plot numbers.
My lord, I'm showing you, lord. At page, that will also tell you the same. Just a minute.
No, not in one of
Just.
you pointed out. No. So report একটা ছোট্ট tabular করে রেখে।
Or kindly turn to page, my lord, 65. That will clear, my lord. I am grateful to lord. Serial number 1 and 2 of the first table. 13844 is 121. Pukur. 13845 is 139 by 1. That is well at Pukur Park.
844 is 321.
My God. Pukur.
120.
321.
And 845 is 139.
845 is well at
Pukur Park.
এটা আমার কিছু
মানে বদলে একটা বলুন
এটা আমার কিছু
Is 139.
Pukur Park.
139 or 139?
139 by 1.
And the Pukur is 321.
Yes. And both has been considered by all authorities in terms of the directions, saying that no part of the bunk has been filled in or Pukur has been filled in. Now, what will be happen today when the green bench has came to a
No, it was filled in because it
removed,
was removed.
So, Lord, there be an order of status quo. Let them come with all their documents. From 2011, this dispute is going on. First case, 2013. A small portion of the land, 2 kata, single-storied building.
Now, Mr.
My lord, only one
Mr.
thing.
No, Mr. Shardai says that there is a status quo, he is protected.
My lord.
But his other submission is how many times an inquiry will be conducted. Whatever it is, his submission.
My lord.
Now you take instruction that when the DM will be calling the parties and will be hearing and passing an order, that order you place before us.
My lord.
And the status quo will continue.
My lord.
Status quo will continue. We will ask you to comply with that portion of the order. He will be given hearing.
My lord, I will. But my lord, only thing again, my lord, probably I am repeating this. The order, my lord, the ground of challenge, what I understand, the filing of appeal, the foundation of appeal is a decision passed by the Green Tribunal. Now, this Green Tribunal order,
No, that
it
is
is
not foundation.
My lord,
That was in review.
Yes. Review.
Each petition was filed challenging the recent order which was passed subsequently.
My lord, the case
The
of
writ
the
petition-
under the case of the writ petitioner appellant is not that the honorable court has erred in fact in recording, honorable single judge, that this 13845 plot number pertains to my lord 139/1. This is not the case of the writ petitioner.
That is what more is his case. That is his filing, that he is showing the tabular ticket.
No, my lord, this my lord.
That is the final order pass which was challenged by him.
My lord, the tabular thing, page 65, just pointed out by my learned senior friend, subject to your lordship's approval, lordship may kindly take up it once more, my lord. Page 65.
Yes.
13844 Pukur. My lord, the entire plot 321 DH Road, Shivdas Mukhopadhyay. Then 13845 classified as Pukur Par, Shivdas Mukhopadhyay, son of such. This is also 321 DH Road, my lord, after purchasing. My lord, this is
321 is corresponding to 13844. And
no, my lord, subject to correction in this tabular sheet, my lord, 65 once. This 13845, this sheet shows that this is also corresponding to 321. Yes, so my lord, after purchasing, this is 139/1. And this remains as Pukur part. This is not Pastu.
That is 13845 is the adjacent embankment of the pond.
My lord.
So your allegation was that on the embankment he was encroaching and raising construction.
My lord.
Now the DM has the order has been passed that no, there is no encroachment, and ultimately Green Tribunal has said that there is a pond initially sought to be filled up, that has been removed.
My
So
lord.
now what remains? What further DM will do?
They are added as the card. So we produced all this by which he acquired the property. Lord, there he mentioned 13845. Lord, that is Pukur part he is claiming. But Lord, at the time of mutation, he added another tag number. That is Bastu. And Lord, only it is 392 square feet. Pukur part has been recorded 392. He has purchased 2 cutters, 2 cheaters, 17 square feet. Lord, kindly see, that's why His Lordship directed that inquiry is required by the DM. Because in everything, Lord, kindly see, Lord, he has not annexed that document. Your Lordship kindly see his deed, mutation certificate, and thereafter plan sanction in another plot. Everything has been altered. Your Lordship kindly see, I am reading the schedule of the property. Lord, Your Lordship, let me see. Lord, we have collected all documents. Fraud has been practiced. You could see that. No. Lord, kindly see, Lord, the deed he purchased 13845. At the time of mutation, he added another plot on the basis of the said deed. I have annexed the mutation certificate also. There he added, Lord, 13845 and 13843. And here also, Lord, 13845 is only page 1. Yes. If any decision is made, that is prejudicial in the decision of the person. Should you now the reason of the thing? Lord, Lord, kindly see, Lord, he purchased not.
Mr. Ghosh, we will hear the appeal.
Yes.
We will say that as per the learned single judge order, DM will proceed.
Yes.
Now DM will pass a reasoned order.
Yes.
We will clarify that portion.
Yes.
Say they will pass a reasoned order, but that shall not be given effect to till we hear the appeal.
Yes, ma'am, that can be done.
The present
But there is a
appeal-
direction that we should also be heard because we have collected all documents.
That
Yes,
is already
yes,
there.
yes, my
Mr.
lord,
Ghosh.
Well, that is already not there.
Not there.
You are
You are
but যে সমস্ত পার্টিদের তুমি হিয়ারিং করতে বলেছে কিনা অর্ডার ইমপিউটা সবাইকে শুনে কিন্তু স্যার হিয়ারিং করতে বলেন
বলছি Yes.
Well, kindly see order, paragraph 3 of the said order.
Yes.
Notwithstanding this agreement, the petitioner seeks a radiant payment plan to discharge the provisional liability and has paid for suitable installment arrangement. But that day it was hard more than half an hour. We never paid for. But the order passed upon our head.
No, this is a wrong sub.
No.
আবার কথা বলে
That-
দাঁড়াও yes
That is our head, my lord. Kindly say, the law is very much clear. I can prefer an appeal because the CSC, what they have done in this case, my lord, kindly see the paragraph in the state application, page 3, paragraph J.
go and file a review before the learned single judge. Say that we did not mistakenly, this line has gone inside. Kindly do not modify the direction for payment installment. Finished.
My lord, that
No, they have acted upon this order.
Who has acted?
They
pay 50%.
They have what their main intention is to pay 50% and get the electricity restored. That has been done.
We are not interfering.
Subsequently, now they are coming and saying that we have not asked for the payment of the installments.
No.
Where the law says that, but they have to, if they have to get the restoration, they have to.
Full amount has to be paid.
Yes.
For reconnection.
Yes.
That
This is their ploy.
That point has been
So
challenged.
50% payment you are not challenging.
No, we have not challenged because they have agreed for the installment. Now they are coming. Why not we kindly see? This is a kindly, sir. This is our order of 22nd of May. They have paid the amount on 26th of May. We have restored it on 27th. And this stay petition has been affirmed on 16/6. Now, what has happened, my lord? We are kindly see the
Now they are not now they are not paying the installment.
Yes.
No.
Go and take contempt measure.
Manohar, kindly see the paragraph just before the paragraph which my learned senior friend has just submitted. In we have submitted that the Calcutta Electric Supply Corporation Limited contends that the petitioner accepted the provisional bill by signing a letter dated May 15, 2025.
We have stated.
They have accepted. Now, before filing this writ petition, then they have filed. Now, my lord, since they have accepted, my lord, there is no scope for final order of assessment. That period is also gone.
Why?
Final order of assessment has to be passed within 1 month.
Final order of the court has not said anything.
Yet they have not said in respect of giving hearing to them, that has also gone. Because we have acted only upon the provisional order. Which they have accepted. Subsequently, the writ petition is filed. Now, there they have paid the 50%. And
no, how that will, if he has challenged the provisional assessment,
yes,
provisional assessment can be challenged in a statutory appeal.
Yes.
Now they accepted the provisional assessment.
Yes.
They did not prefer any statutory appeal.
Yes, they have not preferred.
So very good. It will be to their prejudice. How you are agreed.
Now we are not agreed.
You ought to have been agreed by this order that I cannot reconnect with 50%. You have to give 100%.
But the only thing we agreed, my lord, in respect of the what has fallen from your lordship is absolutely correct. But we gave it away because they have stated that they will pay the installments.
Acha, Mr. Halda, where you have stated that there was a wrong recording paragraph?
My lord, that is we've stated in the paragraph 2.
Paragraph 2.
Page 3, paragraph 2. That is 3rd page, bottom. We has never paid for the suitable installment arrangement.
By page?
Page 4, first paragraph.
Page 4, first paragraph.
First line.
A petitioner has never.
Your petitioner has never paid for suitable installment arrangement. More than half an hour, this matter was heard. So we never said for installment. What we said, prayer for restoration.
In the where is your writ petition?
Yes.
Not annexed.
We have stated.
So did they pay any portion of the installment?
That I don't have instruction. Probably they have not.
They have paid the 50% of
Yes.
5 lakh 54.
Yes.
Now today we are in the month of July. 10 equal monthly installments.
Here we are praying only to pay for an appeal. Let it be tested whether I have committed theft or not. If entire payment is made, there will be no testing. Whatever the system.
Why? You will get back that amount. If your appeal succeeds, entire amount will be paid back to you. This is done in terms of court's order.
Yes. Well,
So
I am
suppose
saying in the division bench to prefer an appeal before the appellate also. Our allegation be tested at our cost. That order I am praying in this case. Nothing more.
There is no why you are saying that it will not be tested. If you file a statutory appeal, that will be tested, Mr. Haldar. But Mr. Haldar, it is a statutory provision here to pay 100%. Court has granted
That one has been argued before your
that we
lordship.
will be deciding.
That will be decided. That will be decided.
Then why you are disagreeing with this? Pay the installment. Pay the installment. Why should we interfere, Mr. Haldar? Had it been strict, which you are arguing in that matter, today suppose it is a held that no, 100% has to be paid. You have paid 5 lakh and odd.
Yes.
Remaining is in 10 installments. What is the problem in that? Now, ultimately, if you prefer appeal,
yes,
that amount which is paid, if the appeal is allowed, assessment is set aside. Can they retain that amount? They will have to return it to you.
That direction.
The expert look out.
That direction.
Of
Let me prefer an appeal. That is the only.
You withdraw it. Why you are inviting an order from us?
Not only this matter, there are 3-4 matters are coming, same type of order. That is the whole difficulty.
Yeah, I think just a minute. So that does not this order does not prevent you from filing any statutory appeal. Is it so, Mr. Mukherjee?
No, if the matter is...
That time period is over, no?
That time period, that
Still there.
30 days,
30
because
days.
that time period is over, in the sense, there is no final order of assessment.
No final order?
No final order of assessment, because they have already accepted.
Oh, now the final order of assessment, then they will... Oh, the final order of assessment. Now the final order you will pass.
No, they have already accepted the provisional order by signing Annexed 2. That was my categorical submission before the single bench, which was recorded in the order at paragraph 2.
Well, that paragraph.
Kindly see paragraph 2. The Calcutta Electric Supply Corporation Limited contains that the petitioner accepted this provisional bill by signing a letter dated May 15, 2025. That is annexed 2.
Now, what is your instruction? In view of this, you will not make any final
No,
assessment?
since you accepted, there is no scope of giving any argument and on in respect of final order, because the provisional order itself is accepted by him.
No, that is your submission. Your content.
No, they have accepted. I have the annex.
That's also recorded in the order. Disputes this assertion.
Notwithstanding the disagreement.
Yeah, that is disputed, but we have shown,
how you will not, this order will not, then you will not be following your own statute.
What we follow, if
6 million private plan.
Provisional time. Provisional time. Provisional assessment. The appellate postal. Then you go to the single judge and Mr. Because you are saying court has detected what 50% and remaining in 10 installment. Your argument is if we pay the entire amount, final assessment order will not be passed. There will be no statutory appeal, and you will be deprived of your.
That is all.
ওরা যাচ্ছে on the basis of this
Provisional.
টাকাটা দিয়ে appeal করতে পারে তো যেহেতু এটা accept করে ফাইনাল বিল তাকে একটা চ্যালেঞ্জ করতে for reconnection. কিন্তু ওটা একটু পাঁচই করবে কারণ না এইটাই ফাইনাল হয়ে যাচ্ছে প্রফেশনাল. Once he accepts the provisional bid assessment, that assumes the character of a final assessment.
Yes.
But then that once he accepts, there's no question of an appeal.
So in this sort of a situation, your authorities will not pass a final order of.
No, that's because that provisional order except becomes a final order once he accepts.
Very good. Now, if he wants to, if it becomes a final order, if he he has a right to prefer statutory appeal.
Yes, but in this kind of situation, it is the final order comes in respect of their consent in accepting it. That yes, I have done this wrong. Then, my lord, in my submission, my lord, that statutory appeal provision goes. Once I accept my mistake, then there is no scope of assailing that.
clarify করতে হবে.
Then Mr. Haldar go back to the single judge and file appropriate appeal. So we will record that you will withdraw this appeal with leave to take appropriate steps in the writ petition.
That order be passed, otherwise, my
Record
that order
Record that you are we are dismissing the appeal as withdrawn. With such dismissal will not prevent the. We are because we are not recording, wrong line has gone into that will prejudice you in the writ petition. On the prayer of Mr. Haldar Learned Advocate appearing for the
একটা দিয়ে রিপোর্টটা এটা অর্ডারটা
modification application file. Yes.
May I please, Your Lord? My Lord,
Oh, আজকে matter table.
tomorrow is that?
2 p.m. we have another.
Oh, yes.
Tomorrow we will.
Yes, yes, yes. Sorry.
In this matter,
Lordship, in this matter, I'm appearing on behalf of the respondent bank, Lordship.
ঠিক আছে। Though it was mentioned, but the point was not specifically taken or prayer was made. Therefore, I am seeking my lord's kind leave, we can make an application, let him decide. That leave may be granted. So in the meantime, they cannot proceed, of course, till the point is decided.
ও যদি মেনে নেয় তাহলে ঠিক আছে।
এটা তো মেরিট ওখানে হবে। That will be decided on merit by the appropriate tribunal.
My lord, since on last occasion, my lords has directed us to carry the copy of the application to show whether they have taken this point or not.
I've said so.
So let DRT decide the entire issue.
Yes.
Parties are represented. One of the primary issues is regulation.
Automatically থাকছে না ওখানে গেলে পরে point.
Question of the appellate being covered by the provisions of the
ইনকোয়ারি করান এর উপরে।
May I please, Dr. Miller? May I discharge the home task? Because the spiral binding, page 237, that has been a basis in the judgment for saying that persons who have done very good, very bad in academic results, they have been given high aptitude marks. That. But the first question is the spiral binding is at all reliable by the judge? A learned judge should have relied upon it or should have ignored it. And you see the spiral binding, page 237, volume 1.
873 paper, volume 1. Wooded appeal paper.
What is the authenticity of this spiral binding? What authenticity? It has been page. It starts from page 123, volume 1. It is prepared by the writ petitioners, litigant. No, nobody has placed his oath on the correction on this document. Volume 1.
Nobody has?
Volume 1, Milord.
Yes, we got it.
Page 123.
Yes.
It starts. See, Milord, it starts. What is the hereby good? But nobody has placed his oath. There is not supplied on supportive affidavit anything. Just place before the court at the time of middle of the hearing.
Yes, that was accepted by the board.
Accepted by the court, and
you were not parties to the writ petition.
Board has court has accepted. My humble submission is, and board as usual did not do anything, kept quiet. Board did not object anything.
Yes.
But board did not object. That doesn't mean it is. I cannot object. Appeal is a continuation. I'm very short on that. It is a document prepared by a private party without not supported by any oath or affidavit anybody. Now I'm going to see what the purpose of this 123 starts. Page 123. Serial number 1. Heading 2014 TATE and 2016 recruitment process. Vacancy was 42,949. That figure is correct figure. Similar. Now, what is the first objection? This is primary TATE 2014 লিখিত পরীক্ষা OMR sheet তৈরি এবং তার মূল্যায়ন করার বরাত পায় বাসু বাসু অ্যান্ড কোম্পানি। কিন্তু লিখিত হয়ে পরীক্ষা নিয়োগ আবেদনপত্র এক্সেট্রা how is it relevant?
No, we have taken note. This is an unauthenticated list of documents which reliance was placed by the learned judge, which ought not to have been done.
Yes.
This is your court. Yes.
Yes. So, but this is first serial. The primary TATE, there's a corruption or illegality, not in the 2016 selection process. Please see the first document. Primary TATE 2014. That was prepared by Basura and company. How is that relevant while considering the validity of...
That is because that TATE qualification was essential qualification for
TATE qualification State qualification is different thing. State qualification is not challenged here. Different period.
No, that is not being said here. It is only an information. Are you disputing this information?
Yes, yes, certainly.
So you mean to say
Tell me,
no TET was
this is
sent?
my primary TET examination results is subject matter of another writ petition pending in this court.
Maybe.
Pending.
But you are not disputing that TET 2014 eligibility was the subject matter of selection
No,
process.
no, sorry.
Yes.
That's right, my lord. But eligibility, there is no complaint
All
that
right. There was no complaint as regards the TET.
no allegation in the writ petition that the persons who were qualified by 2014 TET were not eligible.
That is not the.
Then why? The question is all the corruption, etc., allegation of the final petition is all regarding 2014 TET, not regarding 2016 election process.
Yes, that is also included, Mr. Mishra. We
Therefore,
understand that TET 2014 was not the subject matter of challenge of this 2016 recruitment. This ought not to have been taken into consideration by the judge, more so when it is not supported by evidence.
Judge is legitimate, obliged to lordship. Therefore, my lord, when my lord thinking of corruption and say that when I see a corruption, should I keep my eyes shut? Corruption, say by committed by A, on respect of A, for that B will suffer. There is no charge of corruption in respect of 2016 selection process. I shall come to repeat, show you, lordship. I have to disabuse my lord's mind about corruption in 2016 election process, selection process. Is there an allegation in the petition? I'll come to that immediately. I'm now come to me of this, see what concoction is there in this petition. Please come to page 237. My lord wanted me to make submission on this. It is not. It is not.
That we will ask the board, Mr. Mitra. We thought of placing that, but that the board should answer to us. We are not going into that. So
yes.
Will you take us to the judgment? Do you have that corruption? Will you read that? Will you place that? Judgment 8
huh?
18 to 20 second one.
I'll come to that. The judgment. I'll place by 1822. I'll only place that now, right now. I'll place it. I wanted to show you, lordship.
As you wish, Mr. Mitra.
No, then can you, lordship, raise the question 237? See,
237, we are not asking you now. Because you are not parties.
But I have to show. Lordship may not ask. I have to support my case. That these petitioners made an illegal and untenable charge. What they are showing? They're manipulating documents. I just to show you, lordship.
Are those your grounds?
These are manipulated documents. This is not original RTI sheet. See this document. It's not original RTI sheet. It's not signed by anybody.
That I pointed out to you now.
This is not in the pleading apart from that. RIT report against it, retype by them.
Is that your ground of challenge in your application? Is that your ground
of challenge? It's not an affidavit.
In your leave to appeal which you preferred, did you take this ground? Mr. Devbarman, why you are saying to Mr. Mitra, is that a ground in your appeals, leave to appeal? No, I'm saying, is that a ground?
That was not available to the appellants at the time of preparation of stay or memorandum.
Very good. That will be your reply only. We have not asked you to deal with that document. That is what we are asking.
Lordship, the last question Lordship asked me to. What may I shortly show me that incorrectness of this? What is there asking for question? What is the question? Similar. One thing will be clear. Read one by Siliguri, District 1. What is the question to RTI? Just once a question. how many candidates, trained and untrained, can you see one paragraph? 237, question, all the same question. Question 2, how many candidates, trained and non-trained, para teacher, plus case petitioner? What is the case petitioner? I've been told. It is a case petitioner. Have been appointed by Shiliguri District School and Primary School, including all categories of all medium with memo number blank dated between 24/9/2016 till 11 January 2017. So 2021. Selection process in 2016, my lord, kindly note, is stopped in April 2017. But they're asking for how many candidates after 4 years after selection process stopped, how many candidates were untrained. So why? This is to what purpose? Vacancy was 42949. And according to the learned judge, 32,000 persons were employed to fill up this vacancy of 42,000. Therefore, no employment given beyond the vacancy limit under the 216 selection process. On their own admission, there is nothing given. Am I clear, my lord? The one ground is you are given employment busting the vacancy limit.
So your contention is there was no appointment beyond the vacancies advertised.
Vacancy beyond vacancy limit in the selection of 2016.
Very good. What is that number according to you?
This is the number they have given 429. According
you say we will.
I say according to the judge, 32,000 employees. That is the order.
Yes.
Therefore, 32,000 persons were employed against vacancy of 42949.
Yes.
So there is no question of over employment. But I think that
that is not a ground in for setting aside the selection process, Mr. Vick.
That is not the ground.
Ground.
That is not the ground. Very cool. Then I'll stop here.
Yes.
I'll come to that.
That is in paragraph 18.
Then Miller, I shall go as by my lord 1B2. Can you paragraph 17, 18, 19 of judgment? Yeah, judgment. If my lord agrees this file has no effectiveness, I'll stop there.
Because why do we say so? Because in the writ petition which they filed, subject to correction, we
Yes.
didn't find any allegation that appointment was above 42,000. On the contrary, they said that there are existing vacancies. You accommodate us in those vacancies.
I have no objection to
Yes,
that.
that is
What objection can I have?
Exactly.
I am not there. I'm not stopping their employment.
No,
they have stopped my employment. But I'm not vindictive. Let them have as many appointments as they like.
They will become my friends. Later they will become my friends.
Mr. Gupta, that is a fact, na? That there was no appointment beyond 42,000.
No. That's not the case of any. That's not the case of any.
That they will explain to us. They will explain.
No, we are in the selection process of 2016.
Yes.
Admittedly, the vacancy of 42,000 odd and appointment made according to the learned judge 32,000 only.
Yes.
So therefore, no question of. So
Excess
apparently, Miller, after April 2017, further appointments are given, maybe by the board. Maybe that is their case. That is their case.
That is by virtue of court orders.
That is their case.
17. The appointments that were given were pursuant to the court directions, specifically.
That is it.
That was not told by Mr. Dotto. His argument, this point was not there. Anyway, you will give your reply.
Anyway, Lordship is now verifying the selection process of 2016. And my lord, will you please to ask me to consider paragraph 17, 18, 19 or only 18, 19? 18 to 22. These similar was 18 to 22. Can you page 6 and 623 of volume 1? What is the corruption involved in 2016 selection process?
Mr. Mitra, I'm sorry, it should be from 70.
Right, that's my lordship. 17 or not 17. Please, that's it. From the gross illegality in the selection procedure in the recruitment exercise conducted of exercise 2016 conducted by the board, it is clear that board is official, including former president. Did it? So, gross illegality in the selection procedure. What are the gross illegality? As shown in the judgment? Six. First one, 832 candidates below the lowest mark. I've dealt with that.
That you have said.
That was a wrong low mark. Gross illegality, you have confined to the judgment. On what ground court holds that illegality?
That you have explained to us.
Yes, illegally, not corruption. Illegality in the procedure, violation of rule, etc. Corruption is a media creation. Now let's see. Six instances given. I shall deal with each and every one. So is not sustainable. What is sustainable? Suppression by the board. Why? Because board has not produced a document, which according to judge, I have shown the document was produced, disclosure particular given. But my lord, kindly see as a judge, if the respondent does not, suppose respondent suppress a document, what's the consequence in law? Petition will be allowed. So, respondent has suppressed a document according to learned judge, which is incorrect on fact also. But what's the but that petition will be allowed by making orders which are not prayed for in a petition. Law is right. Let me finish this.
Yes, the paragraph, then you argue.
Okay, very good.
Second person, please place.
Election process illegality conducted board is clear. That the board, its officials, including its lower in former president, Mr. Manning Potter, I'm told is a one who is now in custody after arrest by enforcement directorate for transaction of huge money in the recruitment procedure. In which procedure? Lordship doesn't say in the selection procedure of 2016. That's it. Because he was in connection with TATE 2014 selection procedure. And he is not yet he is now released on bail, he is not yet been convicted, found to be convicted. Now, my lord will consider whether it is relevant to consider this factor while deciding the validity of the selection procedure 216. That the president was arrested and in arrest in connection what? Suppose he had committed theft. Yeah, he arrested for that. And that will vitiate the selection process, a public selection process. He does not say he has been taken in custody because of something wrong done by him in 2016 selection process. Doesn't say that. They come to the next, if I read on. If he said, Lalne just said, if a president is arrested for doing something wrong in respect of 2016 selection process, I could understand the relevancy. No. Then it is mandatory process. Conducted the whole affair as a local club. Now is gradually coming to light by investigation of gradually coming to light by enforcement directorate that jobs for primary school teachers were actually sold to some candidates who had the money to purchase the employment. See, my lord. Why is the any instance given? Then a corruption of this magnitude was never known in the state of West Bengal. Okay. But please analyze me. According to him, jobs were sold for money. Very good. There is no basis for no instance given. I mean, judge has not been able to say that jobs were sold in connection with 2016 election process.
Yes, we have taken note of that.
No?
We have taken note of that.
Yes, yes. Similar, this is paragraph 17. So my humble submission would be in paragraph 17.
This has no relevance. This has no relevance.
Does not make out any case of corruption.
Yes, that was the first.
Of corruption in respect concerning 2016 selection process. Does not make out a case of corruption to 2016 selection process. If corruption happened in respect to another selection process somewhere else, that should not vitiate this selection process. Now I shall come to the petition spoilers. Then paragraph behind the bar CBI inspection, then befitting that. Paragraph 18 shall I read now? 260. It is a matter to be noted that the board in its affidavit in opposition, while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principle of law, but however nice or however laudable these principles may be, this court, as a court of justice, will fail to deliver justice, knowing fully well that sense of justice is much above sense of law. If the writ application is thrown out on such nicety of law, as this will mean that in the name of preserving the law, corruption would be proceeded, which is a constitutional court can never be keeping in mind the soul of our constitution and constitutional conscience. I must say that in this secret scam, excellent paragraph. Now it has got 2 points. Let me analyze what the judge holds. 2 points. Firstly, that there is an allegation of corruption in respect of this selection process of 2016 in the writ petition. I say it is none. There is none. I show you. And second is, my lord, a very, very fundamental question of law. I hope Lordship will consider whether agree or not with this. That the sense of justice is above sense of law. Justice without law. Rule of law has no place in my country. Basic structure of constitution, rule of law. And can you deliver justice contrary to law? This is the provision of law. So will kindly sitting in the highest appellate court of the state. Will examine this. Will the sense of justice above the law? The court should deliver justice regardless of law. This is the provision of law. How drastic it is. It doesn't require an argument to be rejected. This is the basis of the judgment of a learned judge of this court. Now let us see first thing, what the allegation of corruption in the writ petition regarding this. Can you take the writ petition, volume 1, see paragraph 17, page 42, volume 1. And see charge of corruption in respect of what?
You're placing from your paper book or from 873 paper?
Huh? Both. Both. I'm leaving both. I shall tell you when going beyond both. Both. Both paper book, depression, volume 1, page 42, paragraph 17. This is the only paragraph we have found. The alleging corruption. The scam allegation is paragraph 17. Your petitioner states that TET 2014, kindly mark this, is the biggest scam of the Education Department of West Bengal. And in this case, the Minister of State of West Bengal, MLA, MPs, leaders of ruling party are involved. So they are all involved in the scam of TET 2014. And meritorious students who qualified for the job did not get chance. And after talking to the candidate, petitioner came to know roughly 14 to 20 lakh rupees were taken for giving in TET 2014. TET 2014. Some people did not get job even. So, my lord, allegations confined to 2014 TET. And that is why in the spiral binding, they have referred to 2014 TET. Serial number 1. That is why I'm placing that serial number 1. Their case is not that. There is any scam in respect of selection process of 2016. Is not the case. Lordship, remember showing the scam that paragraph, page 123, page 123 volume, this same volume, similar, is 120 of same volume, can you see? That is the primary case number.
Yes, we have seen that.
I've seen that. So, when the learned judge says, board did not delete the allegation regarding corruption made, so learned judge is, in a humble submission, my lord, had inadvertently missed or made a mistake that no allegation of scam was made in the petition regarding 2016 selection process. That was regarding 2014 scam. And Lordship consider whether in view of that, is it open for any judge to make it as a serious conclusion that the matter of scam. He is concerning the validity of selection process. And kindly Lordship knows that this selection process or the selection of candidates was challenged 5 years after conclusion. So they knew everything about selection process.
And that too without implementing it.
That's right. Therefore, it is not the case. They came to know of this 2016 selection process after making the petition. This cannot be. They have done so. This is paragraph 18. Paragraph 19, may I now read?
All the writ petitioners are also TET qualified. All the writ petitioners are TET qualified.
Or
they cannot raise a plea that put the 2014 place.
But I don't agree with you, Mr. Dokshi. If they not agree, they must raise the plea, this plea of the grievance in another writ proceedings, which is now pending in this court, not in this proceeding. This proceeding must be confined to this matter. My submission is, if any grievance about the TET 2014, they have the application challenging 2014 TET election, and or join in the writ petition which has been already made and the list of honorable judge regarding 2014 TET, and let them join there or write a fair petition saying that all selection in TET, including the writ petition as well, void. Let them say that we are all elected, we are all selected void. All my selection in TET 2014 is void. They're taking advantage of the selection 2014 process so far as they are concerned. They are not saying our selections are void, and now challenging that in another proceeding which is not relevant, and thereby prejudicing court's mind. That the impartial judge like Gangavada is being prejudiced. Now see paragraph 18 below. Paragraph 18 only come to. 18 ground. Your petitioner states that a board has stated in different cases filed before this honorable court that 442,897 candidates were selected till date, not up to selection process of February to April 2017. Till date is date of filing with the petition 20 September 2022. Till date. Paragraph 18, Milord, page 42. Your petitioner states the board has stated in different cases. My lord,
You are placing 18 of the
volume 1, petition. I'm reading page 17, 18, 19, I shall read. And really, Your Lordship, a point
Yes.
to hit the core of the matter, Your Lordship indicated.
Yes, correct.
18 now. Your petitioner states that the board has stated in different cases, not in these any cases, filed before the Honorable Court, that 42,897 candidates were selected till date. Till date means 12 September 2022. That is date of filing of the petition, affirmation of the petition. And our selection process of 2016 selection process closed in April 2017. This is selection process 2016 closed in April 2017. Last letter of appointment issued after that. And they're talking till date. Well, then what happens? But no merit list of 42 candidates was ever published by the board. So, board should be directed to publish a merit list as a prayer made. Disclose the merit list. I understand. I have no objection. The order being passed. But learned judge rejected this prayer, did not pass any order. I'll come to prayer and it will show. So which is regarding no such finding by the first court of first instance, that merit list should have been merit list are prayed for, and they did not publish, and therefore the board has done something wrong. Board has done something wrong must be in connection with the concerned selection process of 2016. It's no good saying the board has done something wrong in 2014 TET selection process. It's acceptable. You have not done it, your father has done it. And you are responsible for father's job.
You will be affected by your father's sins also.
Father's sin. Father's sin visited upon son. Father's sin visited upon son.
Yes,
Go on, my lord. Did not qualify. The process was not completed in 2017. Department is well aware that Honorable Court should take notice of some persons who did not qualify, did not qualify for TET 2014, but appointed as primary teachers by the board. When? Not under this selection process of 2016. They are appointed as Judge, and Mr. Gupta shows now relevant to show. Because the judge had directed appointment from time to time. This very learned judge.
There was no challenge against your appointment also in the prayer. We have heard that. We have taken note of that, Mr. Mitra.
Taken note of?
That the judge on the basis of the honorable judge on the basis of a writ petition in which you were not parties, the selected persons who got appointment.
That is one thing.
Random said that in such circumstances, 32,000 out. The first submission which was made before us, that is there any prayer towards cancellation of any person's appointment? There is no such prayer. That they will satisfy. That when the domain of the writ petition is within this, that is what you have argued also. We have gone through the
I'm obliged to my lord for remembering my submissions.
Now, Mr. Mitra, we wanted an answer that, like in upper primary, I think in 26,000 persons where appointment was cancelled. In that case also, the allegation was there was corruption. And ultimately, subject to be corrected, it was held that as we cannot differentiate between who got the benefit and who did not get the benefit, we are cancelled. Now, that is why we wanted to know that what is your answer to the allegation of corruption? Jobs were sold, ineligible and unqualified candidates. Sir.
In answer to it, I am showing me, Lord,
Yes.
there is no allegation of corruption.
You have shown us that. So we can proceed, Mr. Mittal.
Therefore, that was not shown to you, Lord. There is no question answer that arises.
Yeah, no, your argument is not, your argument is that corruption issue does not come because there were 6 illegalities which were there.
Yes.
On the ground of an illegality, can you brand a process to be a corrupted process or not? That is your argument, we understand.
But my submission is, there is no allegation of corruption in respect of 2016
and 2016, which you
and
have
when the learned judge holds in paragraph 18, there is a scam, stinking rats are being smelled, is totally unjustified. This is my submission. May these observations do not affect my lord's conscience in the appellate court. In view of stinking corruption in recruitment 2016 proceedings, the judgments are not applicable. Similar to what the judge is holding. All the judgments cited are not applicable because there is magnitude of stinking corruption in recruitment exercise of 2016 conducted by the board. It is nobody's case. And then the judge has not been able to give any single instance of corruption in 2006 selection process. Another very high principle of law has been laid down. If in a case of corruption is raised, then the judgments are not relevant. You are the highest court of appeal in this court. You have to support this. Judgments are not relevant, judgment court not relevant if a charge of corruption is made. This is the then just corruption, and then this is the basis of the judgment. Then we have list of cases he is not mentioning. Then can we come to paragraph 20 now? The affidavit in opposition of the board was filed when all pleadings and petition of the petitioner, including particular suppliers in court, were served and kept on record, and board did not deal with these allegations and those material facts necessary particulars. Repeatedly, Mr. Lottery is saying that without telling the in a judgment, the allegations have not been made in the writ petition. And all the points, the grounds alleged illegality is a judge's point.
Yes.
So the basis of the judgment is based on irrelevant considerations. Incorrect assumption of pleadings and facts.
Yes.
In the what order is being passed? Similar last paragraph 21. And 22 are the paragraphs. In such circumstances, I allow the writ petition. Very good, allow. Allow all the prayers. I don't mind. Then why? The appointment
The
of
prayers are allowed even, if all the prayers are even allowed, 36,000 remains.
all
The prayers, if allowed even.
Even then, let me show you, Lordship, the prayers. I show the prayers. I show the prayer. I don't make any argument with court. I don't argue with court. I make my submission
You
to
are
court.
saying that. You have
Yes.
shown us
Yes.
the prayers.
May I read the order? Allow the petition. In what? That I show you, Lordship, what petition prayer have been allowed. This is the order. Appointment of all 36 candidates who were untrained and at the time of recruitment of 2016 recruitment process conducted by the board in the primary teachers are cancelled for various reasons as have been elaborated above. Very serious order. What are the bulk of so that whatever may be the ground, if my laws are convinced the selection process is totally illegal, no order can be passed against non-parties with a suit affecting their employment. There is settled law and judgment has been cited. If you know, I've filed more judgments. This order of annulment of appointment of 36 candidates who are not parties have to be cancelled, my lord, in violation of national justice. Then no other question arises. Now, my lord, is 36,000 is not the figure ultimately.
Pardon?
36,000 are not the figure of. If pass the judgment, all right, then this petitioners told the learned judge that it should be 32,000. Learned judge, very well, I'm correcting it. See the order. On simply being told by the writ petitioners, the figure should be 32,000 and not 36, he changed it. What the order? My lord, order at volume, same volume. Will it kindly come to page
627.
627. 6 and 27 of this judgment, of this paper book. This paper book. Correction of typographical mistakes, heading. Similar. matter has been mentioned for correcting some typographical mistakes. Mr. Tiwari, Sergeant Advocate, point out, etc. I'm omitting that. Kindly come to 2. We're concerned with 2. Mr. Tiwari, you are the counsel for the writ petitioners. Has also mentioned.
Mr. Mitra, one interruption. That first para, that fourth line of paragraph 7, the number should be 13.796.
13.796 and not 14.910.
You argued that those persons, 824 of
Yes.
3 were, and in fact, 1 was from SC. He got less than 14. Did he get less than this number, 13.37?
What from he gets it? I've shown you from the.
No, we are
even then, they didn't get 13. They're all 12. 12 point. 12 point.
No,
After
your argument remains because
it is typographical error. 14.191 becoming 13.796. Typographical error. It would have been if it was 13.191 by mistake. Typographical error, what will call 14 typed as 13.
Yes.
In this breakup figure, 14.191 becomes 13.796.
Yes.
Just being told by the petitioner advocate.
627.
What does it show? Great confidence, no doubt in that confidence. Then 2.
Yes.
It is a typical mistake. Yeah. And Miller, I admit, Miller, I should have pointed out to you, Lordship, when I'm arguing that 14 is the.
No, it's all right.
It has been
It's all
corrected
right.
as a typographical error and should be 13.796 as a broken figure. Yes. Now, what is the typical mistake? Court has then seen paragraph 2, II. Justice Tiwari has also mentioned that in the paragraph 21, which he has stated appointment of 36,000 candidates, more or less, what is more or less, do not know, who were untrained at time of recruitment 2016 recruitment process are cancelled. Justice Tiwari has submitted that this should be 32,000, more or less, and not 36,000. Such correction is made as it is a typographical mistake. Typewriter mistake, the court has what is typographical mistake? Court has dictated 36,000. Court has dictated the type, but typist made a mistake. What is a mistake? But court has dictated the minimum mark was 13.796. But typographical typist, instead of typing 13.796, typed is at 14.191. Is that believable? Extreme confidence in the advocate, I know. It does not ask any particulars. Show me how it is wrong, why it is correct, incorrect. He does not send for shortened notes, as is normally done by the court. This type stenographer shortened notes is sent for. See, let us see what you have typed it, what you have written there. Mistake with article section 152. That is clerical typing mistake. He has used the expression. But it's a clear case of modification of the order upon oral submission of the petitioner. It's not a case of correction of typographical mistake. After delivering judgment, after becoming discharges judicial duty and function of official, he now modifies the order. And that's one saying of the petitioners would have been. So what's Lordship now realize or see what happened in this case. I have shown there is no mistake. 14,191 was the correct thing from the chart. Remember that. ঠিক আছে, চুপ করুন। I have shown to your lordship from the record that 14.19 was the lowest mark from the chart.
But now they are saying it is 13.37.
The petitioner is saying so, therefore it must be so. That's the reasoning. That's the reasoning. And this judgment will do that doesn't require call for many arguments. And now let's come to the question illegality. What are the scopes of illegality? Not I have dealt with parawise. It's not so. Before I sit down, I shall show your lordship and illegalities. What are the summary? And none of them is tenable. None of them is tenable. Only one point I am unable to answer because that is matter of record. Board can only say. First ground, paragraph 7, I've dealt with 832. That is the benchmark of 14.191. But nobody was. Then second, board suppressed some particulars. Very good. Is incorrect in fact because board supplied. Paragraph 8. Supplied. 8. And but lordship knows what the consequence of suppression is not suppression by the writ petitioner, that writ petition will dismiss. Suppression by respondent. And what the Court of Justice do? You will draw at the highest adverse inference under section 115. And had this been disclosed, that would have supported petitioner's case. But when petitioner has made out no case, then what happens? Is the ground for allowing the writ petition? Then next ground is no aptitude test taken. By 9 to 14 says. What is the aptitude test taken? Basis is oral evidence. It is not a case made out in a writ petition. It is not a case made out in a writ petition. No aptitude test taken is not the case. Because all the petitioners got the aptitude marks. More or less or more.
Yes.
Yes. Now, what the basis? Oral evidence. I made my submission. Oral evidence has no value. He has no jurisdiction. Without non-parties were cross-examined. Yes. Now, even the oral evidence do not support this conclusion. Why? Only 4 districts out of 20 interviewers of 4 districts out of 20 districts was called for examination. Only 4 out of 20 called for examination. And those called, 9 of them said, yes, it was taken.
5 out of 20.
5 was not called for evidence. 5 envelopes were opened, Howrah, envelopes opened, but ultimately lordship did not think it was proper for him to call Howrah interviewers. For reasons best known to him, he opened 5 envelopes, including Howrah. But at the time of calling the interviewers of all parties, he thought interviewers of Howrah should not be called. Maybe some reason he might have thought they might say something contrary. Maybe the evidence may not be contrary. But why only 4 out of 20 districts?
Yes.
Here, when it comes a question of law, the court cannot generalize. And for that, I rely upon a judgment, 1981 Supreme Court. I shall give the comment. আচ্ছা মুখে বলছি আমি করিনি তো তোমরা করনি কেন? This is a judgment to that effect. I have noted. চুপ করো। That is judgment AIR, All India Reporter, 1980 Supreme Court, 1896. Court cannot generalize.
Here?
AIR 1980 Supreme Court, 1896.
No, that is in that compilation you gave.
No, they say it was my mistake. I did not tell them.
Oh, 80 Supreme Court is not in the compilation.
No.
Mr. That we.
I shall give a separate copy for it. Give it, Lord. It is a mistake on my part, and therefore they could not do that. And I own up the mistake and ask for their forgiveness. But judgment is judgment. Now let's come to the point. This out of those interviewers, 9 interviewers did say, yes, aptitude test was taken. And most of them said, I do not know what is the aptitude test. But aptitude test is defined by the rules to test the applicability as a teacher, ability to teach.
Yes.
Here we have another judgment will come into propositional law, that court cannot reassess the evidence in writ court and cannot sit in appeal. Next ground taken is, my lord, that 9-point high marks are given to large number of candidates whose academic score was low. Paragraph only. Not kindly, my lord, and I said before saying anything else, is that a plausible thing? Is it said that a person who has scored good marks in BA or MA exams, their aptitude will be good. There must be a good aptitude. Academic results, is it linked to aptitude test? May I give a crude example? Crude example.
Yes.
Give a crude example, my lord. There are many amongst us here who have done excellently well in academic examination, BLLB, all examinations. But their aptitude towards practice in law has been different. I can give the example by name, I don't give. So, my lord, people look at it anyway. So, my lord, doing it, suppose, my lord, one has got BA first class, first, BLLB first class first. He will be first lawyer in the court. This is an absurd assumption. Aptitude is something else. My lord, a degree gives you academic qualification. You may have aptitude for teaching. You may not have. You may have aptitude for drawing. You may have aptitude for law, practicing. Which is, surmise is totally wrong. Then I shall come factually also wrong. Why? I give you mostly that academic qualifications and mark, 4 out of 3 writ petitioners got academic score so much, and they got full mark.
4 writ petitions.
3 writ petitions.
Okay.
ওদের একটা কপি দাও, আমি একে দেখিনি। page, etc. given. Academy scored so much and they got almost full marks. 5.5, 5.4.5 and 4.4. I am showing that's the only thing that 3 cases, the petitioners themselves got the highest aptitude mark. The next thing to be considered on this score. Next thing you consider.
Your Lordship's kind leave, may I unhesitatingly give a reverse situation. Mr. Shankodas Banerjee had once told in open court that I got a third class in MA.
Third class?
Third class in MA.
Achha.
And then I was very sad, but I don't regret that marks I got in my MA examination. He got third class in MA.
LLB degree is a good treatment.
That was in MA.
We have got many.
It's primary teacher, not LLB.
No. Number you have got many first class.
Just a reverse situation. Academic and the practical.
No, like we say, this master's qualification in LLM, many would say that this does not help the person in practicing.
LLM or doctorate.
LLM or doctorate.
The question is this: knowledge is one thing, you get virtue, but the power to transmit my knowledge to the students, that is another art. I have known lawyers of great knowledge of law, advocacy poor. Advocacy poor. They cannot transmit their knowledge of law. They are not successful. Great knowledge of law. I don't have to. Many. Mr. Hemnath Sannal, one of them, a great lawyer. Knowledge of law is something. Knowledge is one thing. But power to transmit the knowledge to others is another ability. Lesser knowledge perhaps helps that. A teaching ability is that. Transmit your knowledge to the students. Next point, Milord, next choral thing. Next point is, Milord, out of 50 marks, only 10 marks are involved in interview and aptitude test, 5 marks. 5 marks. Other 40 marks are arithmetical calculation. You will get a first class in BA, your mark will so much, etc. So, Milord, if for the 5 marks, the 50 marks calculation, it will be quashed. How far is relevant? The aptitude test marking was wrong. How about wrong? And secondly, my lord, I must have appreciated by now, the court cannot say that the result aptitude test of the interviewers, I can sit in appeal and say is wrong. Court cannot sit in appeal over the reports of interviewers and say I'm wrong. This is law, not judgment will be there. Judgment is there. We should. Now come the last point. Substitution. What is the last point? That last but one point. Next point is no empanelment of candidates in reserved category in the panel of general category. Paragraph 15. How does it affect? Paragraph 15. Yes. Now, this is a ground. Again, no pleading. Again, judge's case. This is in paragraph 15 of judgment to get it. 15. 15 of the judgment. No pleading. But court's basis is board has not given a reply in respect of the allegation of petitioner in the pleadings as to non-compliance of reserved category candidate in the panel. See, at page 621. 621, paragraph 15. Board has not given a reply. Two of the allegation petitioner in the pleadings. There is no such pleading. No question of no such pleading. Rajesh will correct me. The petitioner he can. I welcome his correction right now. But not we have checked, have missed it. And as to non-cut, therefore, it has been done, must have been done. This is how. This is which means can you have got better marks on general category is valid for general category mark to those reserve category candidates who got better marks than the general category candidate in open competition. Thus, the board has violated the law declared before court. How far did it affect the writ petitioners? How far it did affect the results? In that spiral, there is a reference. Should I take your lordship time to show the spiral? What they've shown.
What?
In the spiral, there is a reference.
Reference
of this is to Purve. There is showing that these are the SC candidates who got higher marks than the general category candidates. Yes, they have given. You look at it, you will find that all those SC candidates have all been employed and given appointment letters. Why I tell you? Because in that spiral, they disclose the breakup of marks of those candidates. And breakup of marks were disclosed by the board only in respect of successful candidates. So they are not affected. So if you want to see that, I can show you a lot. So it's useless exercise by the court. There's a paragraph বার করো ওটা দেখেছি আমি তুমি দেখেছি প্যারাগ্রাফ পেজটা বার করে দাও এই তো
There were in which district? Do you know how many?
I do. No, nothing is in the
Show us that
petition.
paper. Please show
Nothing in
us.
the petition.
So, Mr. Mitra, please show us that paper.
Spiral, from the spiral. Yes, spiral. I'm looking for the paragraph. বার করে দাও না huh? 153, acha. Please will not come to 153 of the volume 1. Yes, they have given a number of 42 candidates, 42 SC candidates. 42 out of 1 lakh candidates, out of 32 successful candidates. And all of them, have given the state score, MP score, higher secondary
All
score.
of them were appointed. This is only in respect of Murshidabad.
Yes, that's what they've given. I'm showing, even then it shows that those ST candidates were all given employment.
In all the districts.
Yes, because I'm telling you this is no of the record. The breakup of the score made by the candidates were disclosed by the board only in respect of successful candidates. And they've given the breakup of the score. That shows these are all successful candidates. They've given the breakup score, test score, Madhyamik score, higher secondary, then Viva marks, aptitude marks, everything given.
Yes.
They're all successful candidates. Now, Where was the fault then? Whether they actually given employment, got it. And none of them is complaining, my lord. None of them has come forward. None of this has come forward and make a complaint about the alleged non-empanelment in the general category. None of them is complaining. Why not? Because after getting the option to get the general category, none of them has complained. None of them is writ petitioner. 5 years have passed. So, is there a ground for causing election? Now, last ground is no selection committee was appointed. That's also a new ground, new point. A new point by the judge. So, no way, nothing. I am unable to say anything. Both can say. It will matter of record, let both say. Both say, follow. You say so. Follow.
They could not say that no selection committee was constituted.
No. Selection committee was constituted. Subcommittees were constituted.
No.
If, once my statement concludes, my lord, I shall.
Thank you. I'll throw another.
No, we have heard you. Let us see. Now we have to see those allegations which have
Only
been.
I'll take 5 minutes.
No, Mr. You will get your chance in reply. We will hear you. If it is published, not published. That's all right. Yes. So this about no selection committee, there is no pleading also in the writ petition.
No
That is
selection
what-
committee, judge is saying another thing, it's for the board to say. I do not say. Now, it's a question of fact. If the petitioner do not allege that no selection committee was
That is what we are asking. No selection committee averment is not
not
there.
in the petition. So the board on affidavit could not deal with this. Board in the affidavit could not deal. If the court asked the question to the board, then board could have said.
Thank you. Yes.
Now, my lord, I humble submission on this second point is, court has on this aspect relied on wrong rules. Please see the judgment, paragraph 1 and 2. It relied on a rule regarding selection committee and all that. Rule 7. Rule 7 was amended, which the judge has not taken note of. He has gone on the basis of unamended rules. Page 611.
Rule 7 is in para 16.
Was amended.
Paragraph 16, rule 7.
6.3. It is a rule
6.2.
6.3. This
Paragraph
relaxation.
Paragraph 16 is rule 7.
Okay. Now, please will not come to paragraph 17. 17 of judgment, yes.
Amended with
17. I'll give the date. Yes. And we have got the amended rules. To your lordship. What I will 79?
No, amendment was, I think, that.
17 is what to bolo. 16 bolo. 16. Now, he has relied on, learned judge only relied on paragraph 16 of the judgment 622. And he relied on this. I have dealt with. Now, he relied on relevant rule 7 of recurrent rules, mandate constitution of selection committee, no selection committee was constituted. This is a rule prevailing before amendment, before the selection process started. Kindly take the 2 dates, Milord. This rule, which annexed to a writ petition, that was amended before commencement of selection process. On 21st September, copy there, 23rd September 2016, Rule 7 was amended. Substantial amendment, giving power to make subcommittees.
এটা আমি ভুলেছি।
And I'm told these amended rules have been 23rd September 2016, and the advertisement was issued on
26 September.
Yeah. And what I'm told that this 216 selection process was initiated by issue of notice or advertisement on 26 September. Page 40. And paragraph 16 of the judgment relies on a rule, relevant rules, Rule 17. I'm told a handed copy is given to your lordship. They have just
The advertisement.
Lordship. The rules copy has been given to your lordship previously.
Even
And they'll also get the date of amendment, etc.
নিয়ে নাও। Yes.
On this point, the next point is this, madam. On this point, selection committee, the court, Honorable First Court, did not give any opportunity to the board to say whether selection committee was constituted or not. From the judgment, it doesn't appear to be so.
No allegation was there.
No, that's why.
That you have
Without
argued.
asking the board, Lordship, Lord should have said, paragraph 16, no allegations there, but this case struck me. I asked the board, have you constituted selection committee? Board said no. Then I could have understood. It would have been fairness in justice. There's nothing in the paragraph to indicate board was asked and board said no, we did not consider. My lord, I'm coming to end the Lord, may I cite one judgment which is unreported, given by a coordinate bench, your lordship, a predecessor coordinate bench, regarding this very selection procedure of 2012, 2014. It's 2014. This is the judgment, my lord, and see, my lord, under similar, their lordship held that the selection was made in violation of NCT rules, held so. But lordship, what the view of the division bench? This same thing, this challenge was made, writ petition challenge was made after 5 years, as in our case. Court said, you've allowed this arrangement to continue for more than 5 years. Now, if I set aside selection on this ground, it will upset the understanding which is going on there. First is below, first paragraph, propriety of the first teacher eligibility test conducted in the state is called into question in present proceedings. Examination for the year 2012 was held on March 31, 2013. In our case, I give the appellants assailed the judgment and order of February 26, 2016, by which their petition under Article 20 was rejected. And this was upheld by the court. See what reasoning? Date is given. And then court holds, yes, there was NCT violation. আমার বইটা পাচ্ছ? আছে, আছে। এটা দিয়ে দিচ্ছি, হ্যাঁ, হ্যাঁ। Milord, paragraph 2. State was held in March 31. According to the state, nearly 30 lakhs candidates took examination. Is also a mission of the state that appointment to more than 17,000 primary school teachers. In our case, Milord, 32,000, according to learned judge. I could not read petitioner, so to say. I could read petitioner as adopted by the learned judge, have been given on the basis of 220 test. Subsequently, the process of appointment has been delinked from TET, and passing of TET is now an essential eligibility criteria for appointment of primary teacher. Now, Milord, please come to Milord, the relevant part of the judgment. Yes. Paragraph 15. In other words, conclusion, the irregularity or illegality on the part of the state in providing for a mode of examination which is at variance to the guidelines issued by NCTE is a matter that must not be missed. But the present appellant challenged the propriety of TET 2012 cannot be assessed on such ground since appellant chose to sit for the examination, here the same case, with full knowledge, same fact, that the mode of conduct examination was variance NCT. All route guidelines, everything is right. As to binding nature of NCT guidelines, appellants refer to division bench judgment of this court, rendered matter of Sir Raja Chatterjee's case. In the judgment pronounced in August 13, 2015, the question that failed for constitutional division bench in that case was whether duration of TET could be 90 minutes instead of what has been prescribed in the guidelines of February 11, 2011 by NCT. This court clearly held in such case, if the test is to be held as per guidelines, it follows the test has to be held as per the amendments made to the guidelines from time to time, unless legal issue amendment challenged. Then, paragraph 19, the court holds there is a violation. Paragraph 19. In the light of the both division bench of this court and the Supreme Court declaring that guidelines issued by NCT for TET are binding, is not open to the state to contend to the contrary or seek justified TET 2012. But to repeat, the challenge in this case has to be limited to the examination itself and not the mode of conduct thereof, the duration thereof, or the total marks allotted therein. Then before single base, can you see me the paragraph 22 now? Now, because what order come? In the light of the aforesaid, it is apparent that TET 2012 was not conducted in accordance with the binding NCTA guidelines. However, it must also not to be lost sight of that TET 2012 was completed in the year 2013 and was held as an eligibility appointment test in the state, pursuant to which 17,000 vacancies at the primary school level have been filled up. These thousands of teachers have been entrenched in their position for nearly 5 years. In our case, now it's 8 years. Now 8 years. In addition, TET 2012 was a huge exercise, particularly since it was for the first time that such eligibility test was conducted in the state. About 30 lakhs candidates appeared. In our case, more than that appeared. Then, my lord, paragraph 23. Principal reason furnished in the judgment, etc., is and to that appellant having taken part in the examination were not compelled to challenge cannot be accepted. Cannot be accepted. That was not accepted. Then, my lord, paragraph 24 and 25 and 26. Court did not disturb. In dealing with a matter of such proportion, a larger picture must never be forgotten. Same is my argument, submission here. There are some 19 or so appellants in this case, out of nearly 30 lakhs. In our case, 140 out of how many lakhs? 1 lakh 20, who took state instance, who have stayed back who have stayed back to pursue the challenge stayed back, even though it might not be proper to presume that overwhelming majority of the candidates accepted TET for its validity. What is important is that only there is an insignificant minority has come to the challenge, in minority. 130 out of how many lakhs? 1,20,000. Then, my lord, instead of robustly repelling the challenge, board and the state have graciously accepted that there are irregularities in several questions in respect of different subjects in state. State has also accepted that the action may be issued in its court to hold any future state strictly in accordance with the prevailing NCT guidelines. State has also offered then 27 order. In the backdrop of the state's stand, the appellants only appealed to the court to allow additional marks to be allotted in TET 2012. For such of the question, we did not adhere to NCT. We not let them additional marks to be given. Earned by the may make them eligible and be considered as state passed. However, if such course action now adopted in this court, it would disrupt. This is my submission. Disrupt the entire system for all the other candidates would then be rightfully claimed additional marks and seek to clamber over mileage 26%. Then, in the circumstances, it is deemed just and fit and convenient to notice that there were serious irregularities in the conduct of TET 2012, both as to mode and the examination, and as to the question set therefore. The state is directed to ensure that future TET examinations are conducted strictly in accordance with the prevailing NCT guidelines in such regard. TET 2012 and the results of TET 2012 are left undisturbed because of brighter and more wider question. Is educational system of a state is involved. And that system is going on for last 8 years now. They came after 5 years. So even if there has been violation of rule, which I do not admit, I said no violation of rule, even if violation of some rule, various questions arise, which is mandatory, is that efficient process, and whether it should be done now when on the basis of the selected candidates have held office and act as teacher since April 2017 they have been appointed. And now we are in the year 2025. 8 years have passed. They came to court after 5 years, as in this case. On that ground, I am placing before Lordship, adopting this judgment. I place a broader question before Lordship. In the broad interest of the state, the education system, will those systems be disrupted now? Even if there's some maybe violation of rule, there's none. But no question of corruption in the selection process. That is out of question here, up to 2016. There is no question of corruption. Then why should it be done? Is it not? Your coordinate bench did only 7 years back. Under similar circumstances, assuming there's a violation of any rule, assuming, even then, the system continues. But I will humbly submit below, coming to an end below. In the writ petition, lot of arguments are normally made, court can mold the relief, etc., etc., etc. It's not a question of molding the relief. It's a question of addition of a totally new relief. new relief. And Miller has been held by Supreme Court that new relief, which is not claimed in the petition, cannot be granted by the court to the prejudice of the parties. A new relief can be granted whether which does not cause any prejudice, maybe. But this is number one. The judgment 1991 SCC, I'll give that judgment. Number two, a court to avoid judgment cited court mold the relief, etc. Next, number two, why the court could not do it? A court cannot create a new prayer, a new relief, and grant a new relief, which will be in violation of natural justice and be void. Namely, an order to be passed by the court against non-parties who had no opportunity to appear, who had not given any notice. A judgment has been cited by Mr. Kullan Bandabad on this 2014 SCC, and there are other judgments, galore judgment we can cite, but do not multiply. But this particular matter, my lord, even assuming there's illegality, everything, court could not pass any order annulling the appointments of 32 persons who were not made parties, whose representatives were not made parties, and the writ petition was not made in representative character. As observed by Supreme Court in such cases, huge number of us involved, then make 2 or 3 representatives, issue a notice in the newspaper, advertise, and then order on rule 8 principles will apply. Therefore, that is without jurisdiction. And this new relief annulment should in any event, apart from going to any further, should be annulled on the ground of injustice, principle of natural justice violation. That's these 2 judgments. I give the in my addition and give a review to learned friend, other side, and give a copy of that judgment.
These 2 judgments.
Not in the compilation below. 1991 Supreme Court and this division main judgment.
Mr. Mitro, please make as Mr. Bandopadhyay has given us the judgment, the point in which point you are citing the judgment and the paragraphs of those
that I've told them.
You can give us a copy.
Lordship, the next day, Lordship allow us to, we have made the index of the judgment. I will give the index mentioning the keywords. Why the keyword? Then the judgment for this, the no order against non-parties. Like this. Whereas Lordship can, that's I'll add that.
Thank you.
That I have to do personally.
Officer will allow my have to just change the index.
Pardon?
Change the index.
Which one?
For the compilation, I have already
আমার নিয়ে গেছিলাম
আচ্ছা তারপর আরেকটা ইন্ডেক্স মেরে দেব এখন কি আছে
You have given us this দাও একটুখানি
compilation without keywords.
পেন্টের compilation একটা দিয়েছিল এই যে উপরেরটা কাটতি হ্যাঁ
কম্পিটিশন ওটাই দেবে ইন্ডেক্সটা বলতে দেবে ওটা মেরে দেবে তার
You have given us this compilation.
Lordship, we are my senior has added.
Please give
the keywords are not there. You could not allow.
And copy তোমাদের দিয়ে দেব
না না এটা থাকবে Do you want it back?
No, I'll come with the fresh one. Changing the index.
Yes, no, then let it be with us because
no, don't allow that. I'll give an additional index which will be super special. ঠিক আছে Oh, grateful to my indicating this.
if you can help us, then you can concise your argument. And after hearing them, whatever ground, because just Mr. Mitro submitted that they might raise this point of molding the review. So that is why he referred to that. So after we hear them, we will give you reply opportunity so that at least we can finish it off.
Well, there would be no repetitions. We have taken note of the points.
No,
We are not going to
only
repeat any of the
request you
points.
not to.
So that's the point.
No, that is.